All right. It looks like we now have a quorum and we'll begin the COPRAC meeting. This meeting is being recorded. And before I do the roll call, we ask that anyone who plans on giving public comment to use the raise hand function to indicate that you'd like to do so. Now, with permission of the chair, I'll do the roll call.
Please go ahead.
Justin Fields.
Here.
Ken Bacon.
Here.
Sarah Bonola.
Here.
Elizabeth Bradley.
Here.
Cassidy Chivers. Toby Inlander. Brandon Kruger.
Here.
Joel Mark.
Here.
Eleanor Mercado. Bill Munoz.
Here.
Dina Roach.
Here.
Kyla Rowe. Hunter Starr.
Here.
Thank you. Once again, I'll say if anybody would like to give public comment, please use the raise hand function to let us know that you'd like to give public comment. It looks like we have about about 7 individuals. Make that 9.
Great. Well, Mimi, should we proceed then to our approving of the prior minutes and administrative matters and then take public comment?
Okay, let's okay, we'll do that first. I need a motion to approve the open session action summary from the October 8th meeting. Do we have a motion?
I'll make the motion.
I'll second.
Is that Ken?
Yeah.
Okay. If there's no further discussion, we'll take the roll call vote. Ken Bacon.
Approve.
Sarah Bonola.
Approve.
Elizabeth Bradley.
Approve.
Cassidy Chivers. Toby Inlander. Brandon Kruger.
Approve.
Joel Mark.
Approve.
Eleanor Mercado.
Approve.
Bill Munoz.
Approve.
Kyla Rowe. And Hunter Starr.
Approve.
Thank you.
Justin, did you want to go through the staff report before public comment, or would you like public comment first? If staff report somewhat lengthy, if we could go public comment first, that would be great, but it's your discretion.
No, I think that makes sense. Let's since we have folks who are waiting to speak, I think we should start with public comment. And let me just make a few observations before we start the public comment to those who have joined us today. First of all, thank you very much for taking the time out of your morning to come and speak to us. We appreciate it very much so. In light of the number of individuals who we have who would like to provide public comments and the other external deadlines and matters we need to get through today, we would ask that you please limit your comments to 2 minutes, and that if you have a view that someone else has already stated, if you would like to let us know that you support or endorse the prior comment rather than repeating what is previously said, we would welcome that as well. With that, Andrew or Mimi, if you have any further observations to make, please do so, but otherwise we can start the public comment.
Sounds good to me.
Okay, I'll go ahead and call the first person. We have Todd Kendrick. 1 second. Okay, here we go. Todd, are you with us?
Hi, can you hear me?
Yes.
Hello, my name is Todd Kendrick, and I am the president of the Santa Clara County Peace Officers Association. I represent over 800 members. The CPOA is strongly opposed to agenda item E4, the proposal that would bar law enforcement unions from contributing to candidates for district attorney. This proposal is clearly discriminatory towards law enforcement. It is inherently biased and unethical to bar the participation of law enforcement unions while allowing special interest groups to continue contributing to and funding district attorney elections. The district attorney office is part of the criminal justice system. We in law enforcement should not be banned from participating in any part of the election process for DA, especially when we have dedicated firsthand knowledge of what is needed in our communities. We are experts in the criminal justice system, and our opinions should not be silenced. There are systems in place to address any legitimate conflicts of interest that might arise between prosecutors and law enforcement unions, rules that all DAs are required to follow. It is not wrong for law enforcement unions to want a strong, ethical DA that will be fair and tough, that will be good for the community. And it is not wrong to contribute to that DA's campaign over a candidate that is not the best person for this elected position. I urge you to reject this request to silence our voices and remove our First Amendment rights. Thank you.
Thank you, Mr. Kendrick.
Next, we have Christine Soto de Berry.
Good morning. Can you hear me?
Yes, we can.
Great. Thank you for hearing this important matter. I appreciate the committee taking this issue back up after the legislative session. My name is Christine Soto de Berry. I'm the Executive Director of the Prosecutors Alliance of California, and several of the district attorneys we work with made the initial request here for the rule change. I think there are 4 important reasons that this rule is critically important for the state bar to resume consideration of and pass a rule to deal with. First, there's the issue of the First Amendment issues, and that this has been narrowly tailored and is an issue that has been contemplated in Florida with Williams-Yulee, dealing with judges. Similarly, prosecutors in their quasi-judicial function have many of the same responsibilities that judges do and are unique in their ability to participate in the electoral process. The second point I want to make is that prosecutors are unique and they're unlike other elected officials, and regulating their behavior is more akin to judges than it is to a legislator or a city council member. Obviously, the enforcement of the law is not blind, and the most difficult decisions that a prosecutor makes is about what cases to charge and what cases not to charge. That's never more clear in the cases of police misconduct and how they will navigate those difficult waters. Allowing police unions to make political contributions then to those elected officials creates a conflict of interest. The focus here is on the associations because of their close working relationship with prosecutors, and the fact that they are often involved in providing support and legal representation to individual members of their association when they're suspected of criminal wrongdoing. This unique relationship creates a conflict of interest when a district attorney is asked to fairly evaluate whether a crime has been committed. The existing rules are not adequate to deal with the unique role of the prosecutor. They do not cover the situation that a prosecutor represents the entire public.
10 seconds left.
Thank you. Rather than an individual client, and they have a duty to the entire community. We're seeking the bar's assistance in amending the conflict of interest rules to more adequately deal with the unique position that prosecutors are in.
Your time is up.
The comment is not quite adequate enough to do that. Thank you for your time and consideration of the matter.
Thank you, Ms. Soto de Berry.
Okay, next we have JJ Puglisi.
Hi, can you hear me?
Yes.
Good morning. This is JJ Puglisi. I'm president of the Burbank Police Officers Association, and I appreciate the opportunity to voice my concerns to the state bar. Just because we serve the public in the capacity of law enforcement does not preclude us from exercising our constitutional rights to free speech with respect to support for political candidates and positions. We're no different from any other citizen in this respect. There are already ethics rules governing any legitimate conflicts of interest. This is an effort to silence law enforcement professionals while allowing a superior platform to other special interest groups. This is discrimination against a diverse demographic of professionals in law enforcement. We're aware of the price of victimization and have a heart to advocate for these vulnerable members of our community. Ensuring that we have strong DAs is crucial to such advocacy. In recent times, we've seen DAs abandoning their obligation to victims in favor of the criminals that have victimized them, with the goal of maintaining the support of activist groups. If you allow this ruling for law enforcement, who will be next? Teachers? Faith leaders? This is a slippery slope, and I encourage you to reject this effort to muzzle the voices of law enforcement in conflict with the constitutional rights that these professionals protect daily. Thank you, and have a good day.
Thank you, Mr. Puglisi.
Okay, next we have Mike Nicolini. Mike, are you with us?
I am. Can you hear me?
Yes.
Great. Thank you. I won't rehash all of the eloquent points that my colleagues have made so far. My name is Mike Nicolini. I am the president of the Vallejo Police Officers Association. I too am calling to express my organization's strong opposition to agenda item E4. I will only add that my members are a part, my members and all members of police associations are part of the community in which they live and work. Their voices should not be any less important because they are police officers and are part of an association. It seems, as we all know, the continued attacks on the police profession appear to be the flavor of the month. Please, please do not let this be another slight to police officers. We urge you to not add this language to the rules. And I appreciate your time today. Thank you.
Thank you, Mr. Nicolini.
Next we have Neil Wertleib. Neil, are you with us?
I am. Thank you, Mimi. I appreciate it. I'm phoning in. I'm a former member of COPRAC. I was chair about a decade ago. This is my first and only public comment that I've given in an individual capacity with respect to a proposed COPRAC opinion. And I know it's not on the agenda today, but this is one that I feel very strongly about. It's proposed opinion 19-0003, dealing with illegal contract provisions. And I think the reason why I feel so strongly about it is I think that this opinion is fundamentally flawed, and if issued would be very dangerous. I think it's flawed because the opinion attempts to address Rule 1.2.1, which pertains to conduct that the lawyer knows is conduct of a client that the lawyer knows is in violation of the law. The opinion talks about an illegal contract provision, and a contract provision is not conduct. The opinion continues on the assumption that certain conduct, perhaps any conduct related to an illegal contract provision, is also illegal. It makes the assertion that the promulgation or enforcement of an illegal contract provision is illegal conduct, presumably on the part of the client, although it doesn't say that expressly. And I'm aware of no law in California that says conduct with respect to an illegal contract provision is also illegal conduct. Further, the opinion implicitly assumes that knowledge of an illegal contract provision means knowledge of illegal conduct, which I think is a leap of faith that's not expressly made in the opinion. And I think this is a problem that's unfixable because if the opinion were to expressly assume, thank you. If the opinion were to expressly assume that the conduct was illegal, then the whole point of the opinion would become irrelevant and of no assistance. And in that sense, I find it to be very dangerous. Thank you.
Thank you, Neil.
Justin, could I ask Neil a quick question?
Yes, please.
If you don't mind. It's not with the substance, Neil. I was just wondering if you had those thoughts you just shared orally, if you had them in writing. I think it might be of assistance to the drafting team if you're able to submit them either to myself or Mimi. If you don't have them in writing, I apologize. If you're able to transpose them into writing, I think that would be of great assistance to the committee, and I encourage you to consider doing that so that the drafting team can really dig into the thoughts you've just shared.
I will do that, Andrew. Thank you.
Thanks.
Thank you, Mr. Wordley.
Thank you.
Okay, next we have Robert Karlborg. Robert, are you with us? You'll need to unmute yourself.
How's that? Can you hear me now?
Yes, we can hear you now.
Thank you. Good morning. My name is Robert Karlborg. I'm calling in on behalf today of the Redondo Beach Police Officers Association. In the interest of saving some time, I'd like to align my comments with Mr. Kendrick and Mr. Puglisi, and also add that there are already rules and systems in place to address any legitimate conflicts of interest that might arise between prosecutors and police associations, rules that all DAs are already required to follow. Thank you very much for your time.
Thank you.
Thank you very much.
Next, we have Wade Stern.
Good morning. My name is Wade Stern, and I'm the president of the Federated University Police Officers, representing University of California police officers throughout the state of California at all 10 of our campuses. And I'm calling in here today to express my organization's opposition to the proposal that would bar law enforcement unions from contributing to candidates for district attorney. Of course, I strongly support the previous comments made by the other police associations, and I stand united with them. And I would also like to add a few other things. And just remember that the request before the committee today appears to be an overt attempt to silence the voice of law enforcement, and is, in our opinion, discriminatory against our profession. Should we silence teachers who are looking to vote on their school board members? Should we not allow teachers' unions to donate to superintendents? Where do we draw the line that decides who gets to have a voice and who doesn't? If the state bar were to implement a rule or amendment or put forth an ethical opinion as requested, it would damage the bar's credibility, as far as I'm concerned, by calling into question its neutrality. The bar should have a vested interest in avoiding any semblance of partisanship, and it should continue to enjoy the competence and authority provided by California's legal profession. I ask that you stop trying to silence our voice. Why are we being treated than anyone else? You have to ask yourself why this is even becoming an issue. It's clear to me why our voices as police officers are being silenced in the state of California. And it should be very clear to you to this point why even DAs and others are even bringing this to your attention. It's clear that they're trying to silence the voices of police officers, and it just absolutely has to stop. Thank you for your time. I appreciate it.
Thank you, Mr. Stern.
Okay, next we have Brian Zimojewski.
Zimieski, but I know it's kind of hard.
I'm sorry about that.
No worries. First of all, thank you very much for allowing me to speak. I am currently the president of the San Diego District Attorney Investigator Association, and we are police officers. And I won't go into everything, but I do strongly oppose, and my association strongly oppose the change in agenda item number E4. Simply put, I am the president of a very small group. We have about 125 peace officers. And one of the big things unions, labor groups do is we allow smaller groups to pool our resources to be heard. Right now, SEIU has over 10,000 employees that they will be able to give their money to whoever they want. And it will silence my members, and it silence our profession. I would really like you guys to think about what you're doing and try not to silence the little person. Thank you very much.
Thank you, Mr. Zimieski.
Next we have, one second, Benjamin Cirillo. Benjamin, you're gonna have to unmute yourself. Okay, maybe we'll come back to him. Brian Marvel.
Good morning. My name is Brian Martin, calling in today as president of the Peace Officers Research Association of California. We represent 77,000 public safety members and over 930 public safety unions. PORAC is strongly opposed to the agenda item E4. The proposal would bar law enforcement unions from contributing to candidates for district attorney. I think you've heard a lot of comments from some of my colleagues, and we echo and support their statements, so I'll keep my statement very short. We do believe this proposal is both unconstitutional and would not survive legal challenge. While PORAC supports the committee's second consideration, I would like to propose another option that wasn't provided, and that's to do nothing. I think taking no action sends a message that progressive DAs can't use the state bar as a surrogate to silence other people's voices. So that's what we would recommend, that you choose option 5, which is do nothing. So we strongly urge that the state bar either ignore or reject the proposal. Thank you very much.
Thank you, Brian.
Thank you, Mr. Marvel.
Next, we have Jeff Swearingen.
Good morning. President of the Placer County Law Enforcement Management Association. I echo the concerns of the previous law enforcement associations who spoke before me. This is an obvious effort to silence those of us who are out here fighting crime and for crime victims. We're all in favor of equal and fair justice, but this initiative is an effort to silence our voices. It is absolutely unfair and discriminatory. It is very transparent why this initiative was presented. As stated by my counterparts, there are provisions in place that mitigate conflicts of interest in criminal prosecution cases, and prosecutors are aware of this. Thank you for your time.
Thank you, Mr. Swearingen.
And we have Marshall McLean. Marshall?
Good morning. Thank you. Can you hear me?
Yes, we can.
Good morning. Sorry. Marshall McLean with the Los Angeles Airport Peace Officers Association. Also joining in on the opposition of the agenda item E4. I mean, we all already know this. We've already heard this before. The fact that it's a second consideration is pretty pathetic. Let's just be honest. This is a splinter group that didn't support what the state district attorneys were about and went off and did their own progressive thing. And now they're trying to use the bar to try and change things so they can get elected. That's all this is about. We all know that this is inherently biased. We all know it's unethical. We all know that this is a way to silence other voices. So if you're going to do this, you need to go and do it for all unions throughout the state. Don't let the SEIUs give to the progressive groups or any of that. If it's going to be about fair, because it's not about anything else other than trying to get these folks elected. So thank you for your time. Have a good evening or a good day.
Thank you.
Thank you, Mr. McLean.
And last, we have Benjamin Cirillo. Benjamin.
Thank you. My name is Ben Terrio. I'm calling on behalf of the Richmond Police Officers Association. I'm also calling to express strong opposition to agenda item E4 and also recommend option 5, which is do nothing. This proposal that would bar law enforcement unions from contributing to candidates for district attorney. I hold this, myself and many other peace officers in the state hold an institution like the state bar up in high regard. It's quite frankly alarming that this thing would even be considered again after this was dealt with in 2020. This request is clearly a violation of the First Amendment, and it's just designed to basically discourage voices and First Amendment activity through political campaigns. And that's what the bottom line is. It's inherently biased, it's unethical. And I think that everyone who's on this call from the state bar should easily see the issue and the conflicts of interest that this is creating. I hope that you take the rationale of the short-sighted proposal to its logical conclusion. All contributions or endorsements, any attorney who runs for elected office should be prohibited, as other commenters have said, if this is the direction that the state bar is going to go. We're not silencing any other members of any other unions. if they're going teachers to school board members or teachers unions to superintendents. So where are we going to draw the line, and where are we going to, where's the slippery slope end? And it's, again, it's just it's just not necessary and not the appropriate way to proceed. And I think it would damage the bar's credibility in its neutrality, and that would be unfortunate. So again, I urge you to reject this bias request to silence voices of the men and women in law enforcement.
10 seconds.
Thank you.
Thank you, Mr. Terrio.
And that is all we have for public comment.
Thank you, Mimi. And for anyone who provided public comment that is still listening, I want to thank you again for taking the time this morning to share your thoughts with us. It's very helpful to hear from the public, and we will carefully consider your thoughts and comments. So thank you again. I believe that concludes our public comment section for the meeting. Anything else in that regard, Andrew or Mimi?
No, Pierre's public comment has concluded.
Okay, great. Well, then why don't we move to the next agenda item, which is the administrative staff report.
Sure. So a few things to report this morning. The first is at their November 18th meeting, I'm very pleased to report that the State Bar's Regulation and Discipline Subcommittee approved the client with diminished capacity opinion for publication on the State Bar's website. It's now listed as Formal Opinion 2021-207. As many of you know, that this opinion was the result of a lot of dedicated time and effort, which addresses a topic on which there is not much guidance in California. And I just want to personally thank and congratulate the committee for the work on that opinion. I'm interested in seeing how it's referred to and utilized by attorneys going forward. And all work of the committee is obviously important, but this one took a little more effort than your typical opinion. So I just want to congratulate and report on that good result for that opinion. Speaking on opinions of the work of the committee, two opinions recently returned from public comment. We'll be discussing those today. Those are the ethical issues when working remotely and the client file release and retention duties. And we received one public comment this morning on the other opinion that's currently circulating for public comment, which is 19-0003, addressing illegal contract provisions. And that opinion has a public comment deadline of December 22nd. I also want to let the committee know about a legislative development that occurred earlier this year that may affect the committee's operations, particularly our new committee members. Our older committee members, this might ring a bell, but with respect to having to notice the location from which we're participating in a meeting. But Assembly Bill 361 was signed into law earlier this year, which continues to suspend until January 31st, 2022, certain requirements of existing law, including the requirements that each teleconference location of a meeting that's subject to Bagley-Keene be posted on an agenda for that meeting. And so based on this legislation, unless there's an intervening change, such as an order from the governor or a change in the law, the committee's agenda will need to post the location from where each committee member is participating in the meeting beginning on February 1st. And so our next meeting after this is January 7th. So that meeting won't be affected by this development. However, our February 25th meeting appears as if it will be. And you can just be on the lookout for further communications from staff concerning this requirement. But I certainly wanted to bring it to the committee's attention. And so for any new committee members or members who vaguely remember but aren't quite sure about this requirement, by all means, feel free to shoot me an email or give me a call, and I can let you know about that requirement.
Andrew, before you proceed, can you just clarify, are you saying that if this legislative development doesn't change, that for the February 25th meeting, for those of us who might be at home, the State Bar would need to publicly publish our home addresses for purposes of our COPRAC meeting?
That's correct. So under the open meeting laws, when there wasn't COVID, the idea was in order to make all meetings accessible to the public, if there's a member of the committee participating in the meeting from another location, that location would need to be publicly noticed on the agenda. And COPRAC had previously followed those legal requirements, but after March 2020, that legal requirement had been temporarily suspended. And even though we meet remotely and anyone can attend these meetings as we are today, Assembly Bill 361 appears to reinstate this requirement where committee members need to notice the location from which they're participating.
So are you aware of any efforts that are being made to clarify or modify that requirement that might obviate the need for publication of home addresses to the extent anyone has a concern about that? Or is that something that, to your knowledge, is not being considered?
I am not aware of any efforts being undertaken as you described. However, staff can make a room available at the State Bar's website to the extent that any committee member is comfortable either traveling to the San Francisco State Bar building or the Los Angeles State Bar building. And, we would make I haven't discussed this with our senior management, but I'm fairly confident we could make arrangements for a room in which committee members could participate in the meeting. And then it would only be the State Bar's building address that would be listed for those persons. I will also say, this is anecdotal, but I'm not aware of a situation in which a member of the public has shown up at a personal address. I know that might be cold comfort, but I do just want to share to the extent that it might alleviate any heightened concerns.
That's actually not my concern, and I'll discuss my concern with you offline.
Of course.
It's a valid one here that we need to address, but I won't take the committee's time. I'm just making a note to myself. Yeah. I think it'll make more sense when we talk about it later. But thank you.
In addition, when you provide your home address or an alternative location, it needs to be an ADA accessible location. So that's something to take into consideration as well, in case a member of public did want to come and attend a meeting from your home or your office.
Any other questions about that? Again, just wanted to bring it to the committee's attention. More information will be coming about that. Okay, and lastly, I have a personal announcement, and I'll try not to. It's been an emotional week for me, so I apologize for dumping all my emotions on me. But professionally, I need to express clearly that I've given I've given notice to the State Bar that I'll be leaving the State Bar, and I've received or accepted a job. It's an excellent opportunity for myself to grow professionally and personally. So I'm excited for the job opportunity. And unfortunately, I had to give the State Bar a notice of my intent to leave, and my last day of the State Bar will be December 21st. And so this will be the last meeting at which I get to staff this committee. I just want to say, man, I'm a mess. Let me collect myself. I apologize. Just it's been an absolute pleasure to be able to serve on this committee. And I just want to convey that I think it's important that we all recognize that we're careful stewards of this important committee, because its work is indispensable in assisting attorneys not only in California, but throughout the country. And it's through volunteers such as yourselves that make that work possible. And, not a lot of attorneys or courts or judges who consult our ethics opinions know when or how this committee meets or how the work is done. But we know how it's done. And they are aware of the final work product. And the final work product assists so many people that are simply unaware of all the work and effort that goes into it. So I encourage you all to continue to take care of the reputation and goodwill that COPRAC has built up over 50 years. And I look forward to working with you on the important work the committee has to undertake today. And I'm going to miss you all and miss the work of the committee, but I encourage you to stay in touch, and I will be in touch with you all. Maybe I'll provide a public comment, you never know. And I hope our paths will cross either professionally or personally in the future. And I know my supervisor and excellent mentor, Randy DeFantorum, wants to say a few words on behalf of the Office of Professional Competence to reassure you that the office or the committee is going to continue to receive excellent staffing support in my absence.
That's correct. I do want to confirm that State Bar is taking those steps to assure that after Andrew's departure, you will have adequate staff council support. At the same time, it is not an overstatement to say that Andrew is irreplaceable. I've worked in the Office of Professional Competence for over 30 years. I've observed many lawyers advise COPRAC on its complex and important work. None have been as thoughtful and caring about COPRAC as Andrew has been. What is seen at these public meetings is just the tip of the iceberg in terms of what all Andrew does for COPRAC. He has been a tireless and extremely effective advocate for COPRAC, as well as California legal ethics generally. Personally, I'm happy for Andrew as he moves on from the State Bar to new exciting opportunities, but I have to candidly concede that this is a great loss to the office. Thank you, Andrew, for all that you've done for COPRAC and the State Bar. It's been a blessing to get to know you, privileged to work with you. And let me just say, someday I hope to see you as a member of COPRAC and maybe even a chair. And I look forward to that day. Thanks, Andrew.
Thanks. I'll have to wait 4 years till all these people are off the committee before I apply, so they don't let my my known reputation tarnish my application. Thank you, Randy. I appreciate it. And I just want to reiterate, today's meeting is not about me, so we do have important work to get to. But I do want to let everybody know about this development.
Congratulations.
Well, yeah, it's I think for all of us, we're thrilled for you, but it's obviously comes with a bit of a sticker shock for us because, as you mentioned, Andrew, you talk about careful stewards. I think everyone on this Zoom call knows what a careful steward you have been for this committee, and we could not do what we do without you over the years that I've been on this committee, and you will be sorely missed. And your institutional knowledge of the committee and the ethicist that you are has been, I can't even articulate how invaluable that has been, not to mention how you've conducted yourself as, just the preeminent professional on behalf of the State Bar. What a representative you've been for them. And it's going to be a very different committee without you. And I want to thank you so much for everything you've done for me personally, for this committee. And I'm really at a loss for words, other than to just express to you how much you mean to all of us and to this committee. And to thank you really from the bottom of our hearts for everything you've done. And if anyone else wants to say anything, great. I'll stop there.
I just like to add, that echo all of that, but Andrew's also taken up the mantle with fee arbitration as well. So you will be missed in that capacity as well. But thanks for everything you have done.
Thank you both. I also just want to make clear, many of you have my personal email address. If there's any institutional knowledge question, I don't think I violate employment laws by being able to answer. Can't speak on behalf of the organization, but just providing my prior experience should it be helpful. And I'm always happy to be a resource for anybody, for anything going forward.
All right. Well, we carry on. We'll make this a memorable, intellectually satisfying meeting for you, Andrew, I hope. And I think maybe there's no better place to start than talking about an opinion we got back from public comment. So why don't we talk about the ethics of working remotely opinion. And I think that would be in Sarah's court to start us off.
Sure. And we received many public comments. This opinion is part of the agenda materials. I summarized the comments we received from both individuals and bar association groups. The one kind of common comment that many individuals and I think most, if not all, of the bar associations raised was the fact that we do not address or opine on the unauthorized practice of law issue in connection with the remote practice opinion. They feel that that's very important in today's environment. And there also appeared to be some confusion based on my review of the comments. I don't know that it was clear to everyone what we had in the footnote of the opinion, which is that we aren't authorized by the state bar to opine on whether activity constitutes the unauthorized practice of law. And so in response to the many comments received, I moved that footnote to the body of the opinion, and I'm trying to find out where that is now in the unauthorized practice of law. I can try to pull up it's at the beginning of the unauthorized practice of law section. Which is I think it's the final section before the conclusion, maybe. Let's see. Yeah, so as you can see, I moved footnote 37 to the second sentence. I thought that might help clarify why we're not going into additional analysis regarding the unauthorized practice of law issue. The other change I made, in part based on the Bar Association of San Francisco's comment, is I did reference the recent Bar Association of San Francisco ethics opinion on unauthorized practice of law. And I also added I think one or two other opinions as well, out-of-state opinions in the footnote, so that at least there's additional guidance that attorneys can look to. Well, COPRAC is not opining on this issue. So those are the changes I made in response to the comments on the unauthorized practice of law issue, although I don't think there's much more we can do given our limitation. So I'll just pause and see if does anyone have any thoughts on this issue or recommendations for edits other than those that I've made, or comments on moving the footnote we previously had to the body.
Maybe it seemed like that everybody seems to think we can or should. Maybe we should be maybe even a little more specific and just instead of saying we don't opine, that we're not authorized to opine.
That might be useful. Maybe can you pull up that sentence again, or that? Let's see.
I seem to recall us discussing that exact language discussion of whether we should say we're not authorized to, or whether we just don't. I think the move to the body is a good move. I mean, after all, some people don't really go to the footnotes despite the fact that they're there. But I think putting it in the body is good, but I don't know that we should start discussing our authorization. I think if we just make it clear that we don't do that, the average attorney who doesn't work with us very much might not know that. And once it's put right before them, I don't think why that is really pertinent to this opinion.
Yeah, that's that observation. That's right, Hunter. We had a discussion, everyone might recall, about this tension between wanting to make sure our readers know that it's not that we're ignoring the UPL issue, but rather it's one that we're not allowed to opine on, but without insinuating inadvertently that we were critical of the state bar for having whatever you want to call it, a policy or prescription, and our opining on UPL. So we were trying to balance with our language, telling the reader we don't opine on this, with not also at the same time suggesting we're somehow critical of the state bar policy or prescription on our discussing UPL. So that's where we came out with this language that you see on the screen. And I think at a minimum, moving the language as you've done, Sarah, from the footnote to the body moves the ball forward in terms of addressing or clarifying for the reader up front, in the text, why it is we're not opining on UPL. So I just raised that tension that we were trying to, work through as the basis for why we came up with this particular language.
Okay, so I'll move on to the other. Oh, and sorry, Joel, you wanted to say something on the UPL issue first?
Yeah, I just have a question. After that sentence, do you think we ought to put in some disclaimer that we're not doing so here, or is that just superfluous?
I think that's repetitive. I think it's I think the sentence is clear that we're not doing so here, but I'm not. I mean, I guess, it might be useful given that there are so many comments on it, but I read it as clear, but I defer to, if others have different opinions and think it would help clarify, I'm not opposed to making that edit.
Well, I'm just mindful of the couple of times when the mandatory fee arbitration advisories have been cited by courts. That kind of disclaimer in certain areas might have been more helpful against some kind of use of this document to justify some conduct that might have something to do with unauthorized law. So unauthorized practice, I'm sorry. So it's just a question. I think you're right. It might just be superfluous, but I thought I'd raise it, see if anybody else feels the same way. Okay, I'm done.
All right, thanks, Joel. So, although the UPL issue is the primary issue, I'll go over some of the other more substantive comments we received from the individual comments. That was the primary issue. Also, the comment from Mr. Furman thought that we should add some additional guidance, in particular regarding data encryption in response to the risks. And I'm sorry, I have a puppy in the background who is a little noisy right now. About the risks in cloud computing and use of third-party providers, and suggest additional language on that. I didn't feel it was necessary to incorporate that comment. There's a lot of ethics opinions that talk about cloud computing, and we reference those for additional guidance, but for the nature of this opinion, I didn't think we needed to go into additional detail. So I'll move on, and feel free to interrupt me if anyone has suggestions on that point. The other, so I'll start with the Bar Association of San Francisco Legal Ethics Committee comments. I'm just going over in the order in which I think they were received. They suggested that we address the consequences of a breach of confidentiality as a result of not having adequate competency. And I did incorporate that suggestion at line 76 to 77 of the opinion. So I'll just, since Cassidy, I think for the Bar Association of San Francisco, I'll just put you on the spot. What do you think of that sentence? Do you have any thoughts on that to incorporate the feedback?
Oops, sorry. My screen is blocking me from, okay, there. Yeah, I think that's fine.
And then footnote 10 incorporates some of the authorities that were mentioned in the letter, and maybe one other.
Yeah, I think that's straightforward.
And then the other comment from the Bar Association of San Francisco was when we talk about the mental health effects from remote practice, it could be derived from remote practice itself and not just from pandemics or other disasters. And they recommended that we note that, and as well as some authorities that support that point. And that suggestion was incorporated at lines 115 to 116 of this draft, in the section where we're talking about the duty of competence, including the mental, emotional, and physical ability. So, yeah, so that sentence on line 116 was added, and then footnote 20 refers to additional authorities on that point. So since I know I've just gone over a few changes that were made, so I just will, if anyone has any thoughts on these changes, please let me know. And if not, I can move on to some of the other comments.
I just had one on the cloud provider piece. Were those opinions that are cited, were they specific to cloud-based providers, or are they just about third-party providers in general? You know, the way I think of storage of client confidential information, the history major that I am, I don't know that all of it is necessarily in a cloud. I mean, I think of, for instance, in litigation practice, third-party vendors ingest all sorts of client confidential data. And I have no idea that it's limited to being in the cloud, or that it's stored on a hard drive or whatever. And so, you know, I think it's a point to be made that this third parties might use the cloud to store, but it's not necessarily limited to that. So I wasn't sure if these were just opinions specific to cloud providers, or they were actually more broad than that, and that we would not necessarily need to limit the discussion to cloud providers.
And Justin, can you note what portion of the opinion you're talking about?
Sure, it was the comment, line 48, and then footnote 7.
Okay. Let me just, I'll have to look at it.
I mean, my point is, you know, we want, I think we're saying lawyers should vet and oversee not just a cloud provider, but any.
Yeah, I agree with you.
That's all my point. And I think we might say that in other places, but it just stood out to me here. You know, okay, I see we're specifically referencing cloud providers, but you know, it seems to me the point applies equally to any kind of third-party provider. So, you know, if there's maybe some massaging to do there, just to make sure it's clear, we're talking about any, whether it's in the cloud or it's, you know, on a hard drive for a third party, it's really any third-party provider. I know the comments, I think, focused on specifically on cloud-based provision, but again, to me, it's any kind of third party is the point.
Yeah, and I'm looking at this sentence and it does talk about, and that's true, I guess, to store backup. And we do talk about other technology solution vendors here. So I don't read this paragraph as limited to cloud, but I'm not certain about the footnote 7 that you referred to. I'll have to double check those authorities. So maybe if you've already highlighted Mimi, so that will remind me to go and I can double check.
Yeah, I mean, I guess the takeaway of my long-winded point is on line 48, I don't know that we necessarily need the word cloud, although maybe it's appropriate to use that word in the footnote in terms of providing an example to the point being made in the sentence in the bottom. I'll just leave it at that. I don't have strong feelings about this, but that stood out to me.
Sorry, this is Eleanor. Can you hear me?
Yes.
Okay, great. Is there any reference in the opinion to privacy considerations or data transfer law? In particular with like cloud solutions, for instance, if you're storing certain types of data, PII comes to mind. There are data transfer rules in place. A lot of cloud solutions provide what's known as processing in the industry, which is just any type of access to the data. You know, it can be crossing jurisdictions or just access in a foreign jurisdiction for support purposes, et cetera. But those types of things require consent. And I wonder if it's worth dropping a footnote that just reminds lawyers of data protection regulations and ensuring that the solutions that they're using are compliant with the regulations that apply to the data.
Yeah, so I know typically we wouldn't obviously opine on that type of issue, but I don't know that in the past, I do think we have in certain situations included a footnote just to kind of warn of other considerations outside the scope of our opinion. So I'm not sure where the right spot would be for that exactly, but we don't in response to your question, we don't currently do so in this draft opinion.
Yeah, I think that's a good idea to have. I mean, because we talk about, Sarah, maybe, I don't know if like 176 or in that area where we talk about, it might not be the right area, but where we talk about some of the policies and procedures that need to be implemented. I mean, it could be other, but it gives examples of types of policies and procedures. I think that's becoming a growing important issue. I think it's a good thing to flag is this idea that when we use these technology companies or third party, what if there's specific privacy policies that those need to be consented. I mean, that's becoming a bigger and bigger issue, especially as we see partnerships between law firms and lawyers and technology companies and the use of information that's being stored and how it's being properly. So I think it is a good issue to flag. And I think it's going to become of growing importance as we see these law firms partner more with technology companies, either in the concept of just like providing those services to clients or, you know, directly to clients or through the law firm or through the websites and things like that. As privacy policies in terms of use that would be compliant.
I'm going to just drop a note maybe around here. What do you think, Sarah? I'm just going to make a note. It doesn't have to go here, but this kind of talks about what you guys are talking about, you know, data security and reviewing the terms and policies of the providers and stuff. I'm just going to drop a note. You can totally put it somewhere else, but I'll just put a note for now.
Sure, that sounds great. And
question I have, and forgive me if it's in here, is there a reference to the lawyer's obligation to obtain informed consent? Like, you know, when you use technology to understand the risks and benefits and obtain the client's informed consent. I'm sure it's in here somewhere. Oh, I'm not seeing it right now though. Because when I approach these types of solutions, I always kind of take the approach that I need to understand all the risks and benefits, and I need to convey those to my client. And that would include things like data transfer and privacy regulations, anything specific to the nature of the data, but also security risks. And so, you know, I think people need to ask themselves, you know, if they're using a vendor, if they're capable, you know, if they have the competence to evaluate the security risks, or if that needs to be done by another party, or if that risk can be transferred to a client.
Yeah, I know more and more people are putting those types of things in engagement agreements, but I mean, I would agree that informed consent would be required if you're going to be, if it requires an aspect where they're going to be sharing confidential information some way via a privacy policy, like, oh, we're collecting all this data and then we share. This is what we do with the data that's beyond, you know, attorney-client privilege, but maybe other confidential information. But do you think that in general that they are required to, and attorneys are required to obtain informed consent to use different types of technology like this?
It's an interesting question. I mean, we certainly treat it as a requirement, and that's probably mostly because it shows up in so many client guidelines that you cannot use a third-party solution without consent, and you cannot transfer data outside of the jurisdiction in which you collected it without consent. This is particularly common with banks because they're so heavily regulated and they have these requirements. They have such regulated data, but it can be true in many other contexts as well, you know, where data has certain protections associated with it. It's also a jurisdictional risk in some cases. If your data flows, you know, outside of the jurisdiction in which you collected it, you may be giving a foreign jurisdiction or foreign nation jurisdiction over a matter. You know, you can kind of stumble into these types of things. So we're pretty cautious about this.
Yeah, I know that I feel that in the past, different co-prac opinions have gone into similar type of analysis and made it really fact specific, depending, you know, one of the factors on the, like you said, Eleanor, the nature of the client data, whether it's as one factor to consider, whether it's really highly sensitive data where you might need to get the client's consent. I don't know that in all situations, we would want to say that informed consent is required, and it might also depend on the type of technology being used to store the information. But do you have suggested language for that, or where you think it would belong in this draft opinion?
You know, I don't right now, but why don't I give this some thought, and I can propose or at least share thoughts.
That would be helpful. And similar with your point on the privacy, if you have any suggestions for that would be useful.
I would just flag, we have in footnote 5, a number of co-prac opinions that address, you know, lawyers' ethical duties with respect to using technology and storing confidential information and things like that. So there might be some, you know, gold for us there in terms of addressing Eleanor's more specific observation. And, you know, of course, wherever we can to tie this into the, you know, overarching premise of this opinion, which is it certainly touches on, you know, these issues, data privacy and things like that. But ultimately, it's about, you know, the ethics of working remotely. So, you know, we want to tie it back to that. But I think that footnote 5 might be a good starting point to see if there's a, you know, something that we might want to add or highlight from these opinions that would maybe address this issue head on.
That makes sense. And I do think the first one is the one I was just referencing in terms of the one that talks about the multiple factors that should be considered in obtaining the client's consent. But I can double check that. Another comment that was received from the Bar Association of San Francisco was that the duty of supervision section should state that the duties of managerial lawyers include the development and implementation of policies and procedures that promote wellness among associates and staff. I did not incorporate that comment. I wanted to open it for discussion, but to me, that seemed more like a best practice as opposed to a requirement under the rule. But I wanted to open that particular issue up for discussion because I did.
Sarah, I agree with you, Sarah. I think I'm not aware of an ethical duty to promote wellness. It's probably a great idea, but I think it's fine to not include that personally.
Yeah, I agree. Given that this opinion is about the ethics of working remotely, it's at the very least tangential, if not really going beyond ethics rules. So I share Brandon's view.
Okay, that's helpful. And I know some of the feedback from other bar associations too, the California Lawyers Association is more concerned about the use of best practices and language we were using in terms of should or could or must. And so I tried to clean that up as I was working on revisions in response to the feedback. So the other comment from the Bar Association of San Francisco was on the duty of communication and a recommendation that prospective clients should be advised about the firm's hybrid structure to the extent material to the representation in situations where the firm's lawyers may not be able to meet in person with the client. And that comment was incorporated on, I believe, lines 131. Yeah, you have it up already, Mimi. So actually it's 133.
I'm not sure I agree with that comment. I mean, I think you've drafted it as well as possible, Sarah, and sort of hedging your bet about to the extent material to the representation, but I'm not sure that the hybrid works idea that's really relevant. I mean, if you had a situation where someone wasn't geographically near clients or they weren't near the courthouse and that was going to be relevant to, it was the type of matter where there'd be lots of TROs or something and they weren't going to be able to get there. I mean, that is inherently, I think, something where it would be relevant where that attorney was or where they're working from, their accessibility. I'm not sure just the fact that they're working from home sometimes or working in different locations at different times is really relevant to most representations. And many clients, well, don't necessarily want to meet in person because you can meet by Zoom and that's not necessarily a deal breaker. For some people, it would be if they said, I need to see you in person once a week and the person wasn't in a place where they're available to do that, that obviously would be material, but I don't know. I don't feel strongly about including that comment in there. And I certainly don't think that the hybrid aspect is what's material. It may be just the inaccessibility of the lawyer to handle, in person the subject matter if it required that. Those are my thoughts on that.
Yeah, Dina, I went back and forth on this one, so I understand. And, by tying it to, it had to be to the extent material, but I agree. Maybe this is something, unless others feel strongly, that we should just remove.
So I share Dina's view. I would be okay removing the whole thing, but at the minimum, I would suggest removing the clause at the end, such as, and the reason, the reaction I had to that is, well, I mean, I have clients who are not in California who I may never meet in person, given the current state of the world. That's par for the course for a lot of lawyers, that they're not going to be able to interact with their clients in person because the clients don't reside in California. So to me, using that as an example, I had a reaction to that based on my own practice, and I don't know that it's the best example for our purposes. So at a minimum, I would cut that, but I'd be okay cutting the whole thing.
Yeah, I tend to agree, and I also think, as I'm considering this more, that I don't know that this is clearly a requirement, as opposed to, as I was saying, more of a best practice like the other issue. So I'm inclined to just remove this entire sentence, even though I initially added it. That'd be my recommendation.
I agree with that recommendation. I think we're I think we're trying to wade into some uncharted waters here and offer great best practice suggestions. But I think it's a little bit perilous to be suggesting that there are ethical duties. Everyone's practice is different, and so anyhow, I'm on board with steering clear.
This is Cassidy. Because I wrote the BASF letter, and I remember we talked about this. I kind of agree with you guys, but I'm conflicted about it because one thing I think maybe I don't have it in front of me, but the virtual law office ethics opinion, I feel like does address this issue and says that there is a duty or something along those lines. So maybe go back and look at that opinion just to make sure it's consistent. And then also, I mean, I have clients who have clients that are, low income individuals. And I think it's important for those types of remote law firms to tell those clients, I'm not going to be able to, we're a remote practice and we're not going to be able to meet with you in person. I mean, it depends on the sophistication of the client in many ways. So that's kind of my only thought with that, as far as having some hesitation to remove it entirely, along with making sure it's consistent with the VLO opinion.
I would agree with removing it entirely, particularly if we're just talking about hybrid and it's not a virtual law office exclusively. I don't think we need that provision in there.
I mean, I think you could, if you were going to keep it in, you could say something like, to the extent where the lawyer is working as material to the representation, that should be disclosed. But I think that's as far as we'd probably want to go. And I don't know that that's necessary, but that's probably how it could be characterized.
I would agree with that. Yeah.
Yeah, I think you'd have to tie it to 1.4A3 to the extent it's a significant development related to a particular employment, the lawyer must communicate that they can't meet in person, because if it's not significant, as you're all alluding to, it's not simply a best practice. You can service the client sufficiently. The client might already be aware by the time they're contacting the lawyer. It can't be a blanket. I shouldn't say it so definitively. It should not be a blanket requirement absent the requirement in the rule. And so the way to tie it would be how Dean is suggesting.
Yeah, I think that's the bottom line on that.
Because even the first half of that sentence, I'm not sure is true. Hey, we work hybrid. Do they care? Do they need to know?
Right. I've had people tell me that, and I was like, that doesn't matter to me where I'm calling you, where you're actually located. I don't really care. I mean, or they have it on. I mean, not that I'm saying they can't disclose that, but it doesn't affect a lot of transactions.
Yeah, if they're like, hey, I got a hearing in the Northern District Court in California, and you're like, well, I'm working remotely from Montana. Yeah, you might gotta say it's going to be a problem, or we're gonna have to come up with a way for the client to pay for you to fly out to appear, or whatever the situation might be. So it's certainly fact dependent. It appears to be fact dependent.
Yeah, and I think that's just what you just said, Andrew, in terms of it being fact dependent too. I think it's just, to me, I still feel that we should remove it. I think it creates too many issues versus a clear-cut requirement here.
So we're removing it. Sounds like the consensus.
Well, if nothing else, it should be flagged and the drafting team can consider it. I mean,
that makes sense.
I think we have a lot to get to today's meeting. I think we've certainly gone through the pros and cons. And maybe if you can't come to a conclusion, you could come up with a sentence that's bracketed for the next meeting. So it's written in the way that you feel most comfortable with, even though you don't agree with it. And then the committee could take a straw poll or some other vote as to whether or not to include it.
That sounds good. So moving on then, there are a lot of other comments. So the final two comments, from the Bar Association of San Francisco, we're not incorporated, mainly because they seem to be issues that aren't really unique to remote practice, but would apply in traditional law firm environments as well. And so in drafting this, I know we try to stick to issues that were unique to remote practice. And even though we tried to do that, I know that some of the feedback we still received from other bar association groups was that some of the issues don't appear unique to remote practice that were in the opinion. So a couple of them were removed in the edits, but the two comments here were a recommendation that the lawyer discuss with the client whether the client has a particular confidentiality requirement. This might be similar to what Eleanor was raising a little bit as well, but whether the lawyer should discuss with the client whether the client has a specific confidentiality requirement to assess whether the firm's existing security measures are adequate. I think that's something that applies. It's not limited to remote practice. It would apply to traditional law firms as well. So for that reason, it wasn't incorporated. I know that is a particular issue that we have discussed in other COPRAC opinions, including I think it's the 2010 one. So it was not incorporated. And then the second comment was,
while we're on that subject, if you don't, the sentence above the one we were just talking about removing, about the hybrid, we talked about before entering an engagement agreement, you should check for conflicts and make sure you're actually dealing with the client. That, to me, that seems the same issue. I mean, that's basic to any practice. Are we suggesting that that's somehow different in the connection with a remote work environment as opposed to any other work environment at a firm?
Well, I think the reason is kind of trying to tie to the remote practice is more what the first kind of line of this paragraph addresses, which is that when you work remotely, you're increasingly communicating with prospective or current clients online or email versus in-person meetings, which might make it harder in that type of environment to make sure you're still adequately screening for conflicts and the person you're actually communicating with is the actual client or someone to act, someone with authority to act on the client's behalf. I think that might be more difficult with the type when you're working remotely as opposed to meeting with someone in person. But
I mean, I agree with the concept. I just wasn't sure whether maybe we were suggesting that was somehow different, because I know, with our firm and other firms, I mean, people contact us through our website, through third-party services, we get emails, sometimes we even get text messages. I just wasn't sure. I agree with the concept, but when to me that seemed we're longer on this topic about it being a basic requirement. I don't know that that's really any different in the remote environment than it would be if you had a physical law office. Apparently that wasn't a concern though, because none of the public comments addressed that.
No, Ken, I think California Lawyer Association, their comments address that to some extent. I don't know if they flagged that particular issue. So if you want to just highlight that sentence, and then when we're working on the revisions, I can consider that with the team.
I think, so Ken, you're saying that this point is not needed to be made because everyone needs to conduct a conflicts check regardless of where you're working?
Yeah, I don't know. I mean, I fully agree with the concept. My concern is that maybe we were suggesting that it's somehow different though, with the remote. I mean,
got it.
Yeah. We were talking in that way, the conversation before I made this comment was the same thing. It's a basic requirement.
Yeah.
I mean, whether you're working remotely, virtually, or at an office, you need to get information to screen for conflicts and make sure you're talking with the right person.
So the only reason I raised that, I'm asking is because I think I'm the one who raised the conflicts issue. And I thought, I'm just thinking of, obviously it's obvious to those of us here at this committee, but I'm thinking of lawyers who might be considering working remotely for the first time. And so to the extent it's phrased as though the obligation is any different, I would agree. We should be careful not to say that. And the committee might disagree, but if my memory is correct, I think I'm the one who raised the fact that we should flag, hey, working remotely, you got to maintain a conflicts database, and don't forget that this is an important requirement, because that might slip the mind of a newly licensed attorney, or even a weathered attorney who's working remotely, doesn't have those larger resources that they might have, conflicts databases and whatever else, when they're in the office or connect to the server at their law firm. Of course, I know there's plenty of ways to connect remotely these days. So I'm only providing that background as to say, I think I'm the one who suggested referencing the need to conduct conflicts checks when working remotely. And the intent was to be a helpful reminder not to let that slip the mind of people who might feel, once they're in isolation, I think conflicts might arise more difficult or more in a larger fashion. I can't articulate it clearly, but it might be overseen when you're working remotely, because you might not appreciate all the colleagues that you normally work with because they're no longer down the hall from you. Whether that's true or not, it might not be the case. But anyway, long-winded way of saying, I thought it would be helpful.
And maybe we said something if, as in the case with a physical or traditional law office, lawyers working remotely must, like, something to that effect.
Yeah, that makes sense to me, Ken. I think in terms of the next iteration, one thing to keep an eye out for is these statements that apply outside of working remotely, and then making kind of have a decision tree. Do we need to talk about this because it really isn't specific to working remotely, or is the point that we're trying to emphasize that this still applies, and maybe even is more so of a concern when you're working remotely? And to then, if we want to keep these types of statements in, to Ken's point, to add a clarifying clause that basically says, whether or not you're working remotely or in a traditional environment, blah, blah, blah. It's a nice little clause to make it clear that we're just trying to emphasize the importance of this, especially when you're working remotely. So, I think that those are the types of statements that we should keep an eye out and see if we can offer that type of clarification that Ken is proposing, so it's clear to the reader that this is not a unique issue for working remotely, but it's one that we want to highlight or emphasize for whatever reason.
Could the same be said of the reference to cloud above? I mean, that's something that crossed my mind when we were having the discussion about the implications of using third-party solutions, particularly cloud-based solutions. I wonder if that's just I think the reference was in connection with backing up data, and that seems like something that would apply whether you're working remotely or not. And by referencing it, I think we invite a lot of questions. Is it a public cloud? Is it a private cloud? Where is it processing data, et cetera? So maybe we query whether or not that's even necessary.
Yeah, as I was making my comment about the cloud providers, I had the same reaction, Eleanor, is that, and I was thinking out internally to myself, are we trying to make a point specific to working remotely, or just as a sort of reminder about these ethics issues, data issues that have been kind of addressed in the footnote 5 ethics opinions? And how do we marry maybe wanting to give a reminder that these issues are important with the fact that this opinion is focused on working remotely? So maybe there's some wordsmithing we can do there to tie the point specific to working remotely, or again, to make the point that we're just emphasizing that these are even more important issues to consider when working remotely because of reason A, B, or C. Similar to this, what we're looking at here with lines 130 to 133 and the point that Ken made about this sentence and how it applies, whether you're working remotely or not. So again, I think these are some overarching questions that we should look at as we're finalizing this opinion.
Yeah, and one thing I wanted to point out is on the point in terms of, you know, whether this is unique or not, or whether somehow it's different. The very beginning of the opinion does clarify that, you know, the application of the rules is the same, whether you're working remotely or in the traditional law firm environment. The application of the rules is the same. It's just the opinion is intended to address rules that are more likely to be implicated while working in the remote environment. And so I think we clarify that up front. And then that kind of helps to some extent. So we're not trying to argue that somehow the application of the rules is different in this situation. And then one other point about the particular, just going back to, I think it was Ken who initially flagged this issue relating to the conflict screening issue. Now I'm not seeing it with, I thought there was a footnote initially, and now I'm not seeing it because I saw it on my draft. But that was something that was referenced in the virtual law office opinion. Oh yeah, it is. It's just following the bracket. I didn't see it. Footnote 23, which does reference the virtual law office opinion for that particular point as well. So I do view this particular issue as something that is something that's implicated more perhaps in the remote environment, even though the application of the rule would be the same. But since we talked about this issue for a while and we'll reconsider it as a group, the subcommittee, I wanted to go on to some of the other comments we received from other bar associations. Looking at the Orange County Bar Association, they were mainly concerned about addressing more of the UPL issue, which we already talked about. I think I'm going to move on to the California Lawyers Association comments. And the first comment was something we'd addressed previously in prior COPRAC meetings, that the issue presented appears to be narrower than the opinions discussion, which is not limited to the duties when working remotely in response to the COVID-19 pandemic or other disaster situation, because remote practice is likely to continue in the long run. And I think we tried to broaden the scope previously of this opinion in prior committee meetings, but there were some instances where we hadn't, and the revisions kind of incorporated some of CLA's feedback on this point. And removed some of the language that is not really, some of the language was more relating to practicing in response to a pandemic like COVID-19, which is how, when we initially started drafting this opinion, we were more focused on that issue, and it developed more into just a general remote practice opinion. But so edits were made on that topic. And the other issue I already went over very briefly is throughout the opinion, there was sometimes we use the term should, where CLA felt like it was an obligation, or in other situations where we're truly making kind of a best practice type recommendation, we should use could instead of should for practice pointers or aspirational conduct. So some changes were made throughout. I don't think I need to go to I'm not going to go over every line item where that was, but I encourage everyone, as you look at this again, if you have particular suggestions on that, to follow up, and we can incorporate more of those edits. But I think the edits captured a lot of those comments that were made by CLA. One of the edits made in response to CLA's comment was at the very beginning of the opinion, on page 2 and footnote 4. CLA felt like it might not be clear when we talk about something a law firm must do, what we mean by that. since the rules regulate the conduct of lawyers. And so the footnote 4 incorporated some of the feedback from CLA on that point, making it clear that law firm is used as shorthand with reference to the responsibilities of the law firm's managerial lawyers, and making it clear that the rules regulate the conduct of lawyers rather than law firms. The other comment was actually somewhat consistent with what Eleanor raised previously we talked about, so I'm not going to go into as much detail because I know I've probably been taking up too much time, but it's just asking that we clarify particular duties regarding cloud providers, and in particular, provide more detailed guidance about duties with respect to cloud providers. I view this as kind of an issue that is something that you could devote an entire ethics opinion to. And in fact, ethics opinions have been devoted to that particular issue in terms of duties with respect to cloud providers. So I didn't want to make it too much of a focus in this opinion. They also talked about, the additional detail regarding small versus large firm, or an established versus a newer provider, and a lot of details about how to vet a cloud provider. I don't think that should be the focus of this particular opinion. So that comment was not incorporated. And then the other comment that we already went over too, that CLA raised, is recommending that we remove areas that are not necessarily unique to remote practice. And that was done in some instances. And as a drafting subcommittee, I think we will reconsider that in other areas that we flagged earlier in this meeting. The other comment was something we already discussed at a prior COPRAC meeting. CLA suggested that we clarify the type of hybrid environment and shared office space being used, such as a WeWork environment. And others might recall that when we initially drafted this, we did say it was a WeWork type of environment, but we changed it because we didn't want it to be particular to any type of shared environment, particularly with the increasing changes of shared law firm environments. So we're trying to make it more general. So I did not think it made sense to kind of specify a particular type of law firm shared environment. And I'll pause there to see if others have thoughts, but I think we already kind of went over that in our prior COPRAC meeting.
I saw one other area where we on the could versus should. It's at line 79 to 81, where we're saying that lawyers should tell their clients who are working remotely to, have confidentially in their own working environments. That was striking me as kind of, especially if we're saying should, that we're kind of maybe creating a new standard there, that you might have some duty to tell your clients to, make sure they keep things confidential on their end. I was a bit troubled by that sentence. I don't know if others are concerned.
Yeah, that concern makes sense to me, Ken. It might be a overly broad statement as it's phrased.
Yeah, I mean, especially if it's using should instead of could. It's certainly a good practice point, but I don't know that, there's necessarily, whether you're remote or, and once again, I don't know that's any different than if you have a physical office versus you're working remotely, because it's talking about the client's end of this. So yeah, I'm almost inclined to say maybe we ought to remove that. But.
Yeah, I'm not sure that we need this sentence, and given the complications you just raised, Ken. I can see that as being an option here to remove it. But it could also be revised if, there's some other kind of point that we can make that's more narrow.
Yeah, I certainly agree that this is more of a best practice type thing, and should was not intended to mean a requirement, but I think we could consider removing this as.
Yeah, I mean, if we're gonna make it a best practice, we may want to, or something like that.
Yeah, I know CLA had suggested for certain areas using the term could, which doesn't seem to fit here. Could remind clients. It just sounds. Yeah, but if we just flag this, we can consider it later as a drafting subcommittee.
It would seem to me that, if you find yourself in a situation where your client has inadvertently essentially waived their privilege, your failure to advise them that they were waiving their privilege might actually be thorny. So I think the concern that we're setting up a new standard is well taken. At the same time, I would think it an attorney's prerogative to be the one to say, hey, you might be waiving your privilege if you're not careful. For instance, if somebody brought in, 3 or 4 friends into a physical office and said, okay, let's talk, an attorney might say, maybe this is inappropriate. Maybe certain people shouldn't be in the room. And I think that if the attorney didn't do that in the physical office, that might be on the attorney. So I think it's maybe appropriate to have it in there, but potentially narrower than telling them they have to take security precautions or what kind of security precautions I think might be too far, but I can see why this would be something that we might want to consider keeping in some capacity.
Yeah, I don't know how it's, like I say, it's a common practice, I know, in the PI field and others, tell your clients, be careful about posting on Facebook. It's a similar issue. It's certainly a good practice, but that was my concern, whether we're maybe setting up a standard. But yeah, I think it's worth at least reviewing.
Yeah, that makes sense, and I agree with you, Ken. I was also reminded of just some of the ABA opinions on this point, like you mentioned about posting on social media, particularly in employment law matters, reminding if you're representing employees, not to use the work computer to communicate with you, which could lead to a waiver of privilege. And but I think if we just flag this for now, and then we'll reconsider how this is worded if we're going to keep it in, to make sure it's clear that it's a best practice as opposed to a rule requirement. Let me just see if there's. Okay, the other comment from CLA is on lines 179 to 180, which talks about, there's a recommendation that we clarify that managerial lawyers are ultimately responsible for the firm's remote practices and procedures, even if they delegate daily monitoring and enforcement. When looking at this, I didn't view the opinion as suggesting otherwise. I did revise, if you look at line 187, this should be to R, to make it clear. But I wasn't sure how else to revise this paragraph to incorporate that comment, where we weren't really talking about, I'll move up, delegating or suggesting that somehow the lawyer could be relieved, the managerial lawyers could be relieved of their responsibilities by delegating monitoring. I didn't view this paragraph as suggesting that. So I'd be, if anyone else has a different opinion, and I know you might not have had a chance to look at this particular area, we could consider further revisions.
I mean, I
I'm a little
thought
concerned.
change to R was fine.
Is this another area where we should think about whether this applies to remote practice more than general practice? You know?
Well, here we're talking about enforcing the law firm's remote policies and procedures. So,
and I'm not trying to throw a wrench in the works. I'm just wondering, you know, at this point, my law firm, most people are working at home several days a week, coming in some days. Are all law firms kind of moving towards that? I mean, is this something that's applicable to all law firms now versus just people that would view themselves as I practice remotely? Like I come into the office whenever necessary, but I don't know. I'm just wondering if it's broader by the day as to who this applies to.
Well, it probably is, but then I also think about the fact that a lot of us, even before the pandemic, who would go into the office every day would also, you know, have our laptops and work from home at night or whatever the case may be. So I think this applies broadly to a lot of lawyers, even prior to the pandemic, in terms of, you know, remote access to work and
right.
And all that.
yeah. I'll just go over because I know I'm taking up some time. The final two comments, I didn't get a chance to go over yet the comments from the Los Angeles County Bar Association, which were somewhat consistent with some of the other groups' comments, which are the UPL issue, as well as the same issue we've been discussing about making sure the issue is unique to remote practice. But there were two additional comments from CLA, just there are two final comments that edits were made in response to their comments, deletions. One about, there was a statement about disaster and succession planning appears misplaced, and that comment was well received and it was removed on, I don't have the particular, I'm sorry, did you find it, Mimi? Yeah, so 192. So that was removed. And similarly, this is a little bit different of an issue, but they question the feasibility of obtaining employee consent to remote locking or wiping of personal phones. And they believe the resources in the footnote adequately address BYOD issues. I know that remote locking and wiping is addressed in ABA and other ethics opinions, but overall, I don't think it's necessary to include that particular area, which is on line 184 to 187, or let's see, or maybe it was already. I must have been looking at a different version. Sorry, Mimi, I'm not sure where.
No, it's just that it's shifted with all the notes and everything.
Oh, yeah.
I can do a keyword search if you want.
Yeah, maybe just search for remote locking. I mean, it was just deleted, that section where we talked about consent to remote locking. Oh, there it is.
Yeah, right here.
So I think that was it in terms of the comments. I went over the majority of the substantive ones already, if not all. And as a subcommittee, I think we'll go back and consider the issues about, I think the primary issue to reconsider is just one, when we're talking about best practices being clear, and also making clear that these issues are unique to remote practice and tying the opinion more to remote practice as opposed to addressing something that might be a generally applicable rule that isn't really unique to the remote practice environment. I think those are the two main issues that require some follow-up.
Well, as long as we're on that spot right there, if you go down to what is now line 197, it starts out managing lawyers and lawyers overseeing non-legal staff. But then in the next line, it talks about work of associates, which would be legal staff. it seemed like we could take out, if we're specifically talking about overseeing non-legal staff, it should be limited to non-legal staff, paralegals, other, but I thought having associates in connection with non-legal staff was a bit confusing.
Yeah, and I think we should keep it broader and not limit it to non-legal staff. So maybe an edit.
Yeah, that would be good.
Yeah.
Made to on 196, overseeing and lawyers overseeing non-legal staff or associates, or we could even say other lawyers, but
yeah,
because it might not be an associate. And then maybe.
You could just say oversee their work, and then you don't have to get into these associates, paralegal staff, and independent contractors, or something like that.
Yeah, that's a good edit.
Sorry, what are we doing?
Just to say, so it would read to oversee their work, period.
Okay. And just delete everything else.
Yeah, and then if you could change it to their work. And then I think we should say though, since we're based on that edit, maybe managerial lawyers and lawyers overseeing non-legal staff, other lawyers, or, well, you don't really oversee an independent contractor as they're supposed to operate independently, but I think I'll just leave it as is. I think this works.
It can be massaged a little bit more in the draft.
Yeah, I think it's not quite broad enough now, but it's highlighted now, and I'll work on that language.
I would just make one other comment, and then I have nothing further. Is that it struck me when you highlighted in our discussion, Sarah, the footnote 23, and there's such a good job is done in many of these footnotes with like an explanatory parenthetical, and I think, for instance, with paragraph 20, footnote 23, if you have a parenthetical that ties that virtual law office opinion to the point being made in the body of the opinion that, you know, standing alone isn't necessarily tied to remote work. It's a way to, you know, make some of these connections. So I think there might be places in the footnotes where we can add a parenthetical to show the connection to the point being made with, you know, the ethics of working remotely. So just a thought.
No, that's a great idea. Thank you.
Any other comments or questions or thoughts about this opinion at this point? Well, Sarah, thank you very much for leading us through this. I think this is in really good shape, and really appreciate you taking the time to and the drafting team to put this together. And I would just say in particular, this cheat sheet that you put together of the comments and what you did to the comments was super helpful to get through this and understand the changes. So really, and obviously it was a lot of work. I really appreciate that. I'm sure that was helpful to everybody. So thank you.
I just want to, sorry, just to chime in. I mentioned this on the colleague, the impaired colleague opinion. I think Sarah implemented the same technique in terms of summarizing public comment, and I've made the comment then. I'd like to reiterate it now. That's an excellent practice for the committee. It's innovative. We haven't really had anyone do it in that manner, and I would just strongly encourage the committee to consider that format, briefly summarizing what the comment is and then what the drafting team's response is. It's just so helpful, not only to go through the comments for the other committee members, but to ensure that each comment had been considered. It's a nice record in that respect. And so it's just an excellent approach and really helpful. So thank you, Sarah.
Absolutely. And I think Dina, Sarah, and I will do everything we can to see that practice become one that continues for the committee, because it is terrific.
I could save that in the other sample in committee resources here on the staff side, so that it will always be available to share with
that's
new members coming up. So if we could tag team it from both sides, staff and the committee, I think that'd be really helpful. Thanks.
Perfect. So we only have 10 minutes. What I'm thinking we'll do is switch to a shorter topic. So I'm going to move some of the agenda items because I don't think this will take very long. We have an agenda item about issue outlines. And if I printed everything correctly, we only had two. One was the cryptocurrency issue outline, and the other was the flat fee issue outline. Mimi, Andrew, anyone else, am I missing any other issue outlines that came up that were circulated?
Not necessarily circulated, but Ken did send an email saying that he would like, he didn't feel that his opinion, which is, hold on, let me find it. 21006, negotiating carve-out provisions warranted an opinion. So there was no memo, but if you'd like him to give a short oral explanation as to why, I'm sure he would love to.
Yeah, I mean, I looked at it, I thought it was kind of a very, a narrow and specific issue. And as I was digging into it, I just didn't think there was enough there where it's something that would, warrant moving forward at this point. So that's all there was to it.
Okay, makes sense. Anybody have a question or comment about that? All right, let me move then to cryptocurrency. Bill and Eleanor were instrumental in putting together this issue outline for the committee, which basically, if Bill and Eleanor, if one of you or both of you'd like to walk us through it, I'll just say a couple comments. If you haven't had a chance to review it, what they or we've done is tried to frame some of the issues broadly as to what we could address, the rules, give you some background with respect to prior ethics opinions and how they've analyzed cryptocurrency, and then started to tackle some of the questions that we might consider trying to answer in an opinion. And I'll leave it at that high level and ask Bill or Eleanor if there's anything that you'd like to say or add about this issue outline. Or the topic.
No, I mean, I think it's in looking at it, I mean, it's a really interesting topic, and makes me nervous as a lawyer. Having looked at these various opinions, I won't use cryptocurrency or accept payment as cryptocurrency because it scares the hell out of me. But I mean, I think the opinions are pretty straightforward. Those that are out there, and I think the issues that we raise are very similar to the ones that are raised in the other other opinions that have come out on this topic, such as in Nebraska and New York and DC. And they largely focus on, a couple of different scenarios. One of which is, can you just use cryptocurrency to pay for attorney's fees? And my example was, I do some work for a client, send them a bill, they want to pay in cryptocurrency. Can you do that? That was one hypothetical, seemed pretty straightforward. The real dicey one that I see that can create problems for lawyers is the situation where you're taking a retainer, not a true retainer, but a general retainer for future work, and you take it as cryptocurrency, and how you deal with that, I think, is really the kind of the nuts and bolts of this issue that I see, because you hit all kinds of different rules are implicated, because most of the opinions have treated cryptocurrency as property versus money, based upon the way the IRS views cryptocurrency, they view it as property. So they think it implicates 1.8.1 transactions with lawyers. And following that rule, but also the issue deals with unconscionable fee because of the fluctuation of the cryptocurrency is so volatile. How do you account for that? When do you account for it? When do you value it? Are just really thorny issues that lawyers who do accept cryptocurrency will have to face. I think some of the larger law firms that I've seen in the articles that we looked at will immediately basically convert the cryptocurrency into fiat currency, so you don't run into that issue as long as you disclose that to the client and say, look, we're going to use this third party. I think the term they use with the Bitcoin basically converter. You got to have who's going to be responsible for the cost of converting Bitcoin or other cryptocurrency to fiat currency. So there's a lot of points there that I think given here in California, I think lawyers would really like the guidance in dealing with cryptocurrency. And I think the topics that you raise are the pertinent ones and ones that I think would be seen by lawyers who use cryptocurrency daily basis or routine basis going forward. So I think it's going to be an important issue to give an opinion on for those of us in California who are going to, not me, but other lawyers in California who use cryptocurrency as a form of payment for their clients.
I would agree with all of those observations. I think, one reason to really consider doing it is there are conflicting opinions out there with respect to whether lawyers should accept cryptocurrency for advanced payments or retainers. And I think opining on that would be very helpful, and giving some guidance on what appropriate types of safeguards might be. I realize that takes us into that best practices category, but at least offering some caution to advise lawyers of the types of pitfalls that are out there when you're accepting property. At least one of the opinions says because it's property, it shouldn't be put in trust. It can't be held in trust. And it's really based on if you can immediately convert it into fiat currency and you're clear about the ways you're going to do that, that it's okay, subject to various other ethical obligations. But I think the existing inconsistency in the ethics opinions is a good reason for us to wade into this.
Thank you.
And I think it's really disclosure. A lot of it is really more disclosure issues than anything, how it's going to be treated, so there's no misunderstanding, especially when you're talking about dealing with the idea about whether it's a reasonable or unconscionable fee, when it's to be valued for purposes of converting it to fiat currency, and when you do that. So I think that's what we're doing.
Right. So I think the committee is probably getting a sense from Bill and Eleanor's comments and what the three of us have discussed is this is a very interesting issue. It's one of those cutting edge type of issues, and we think it's worth exploring further and trying to flesh out this ethics outline and see what it looks like in terms of putting together more in-depth analysis before we would necessarily get into a full-blown opinion, but at least to take that next step to flesh out the analysis and be helpful to have the committees as a views whole as to whether you agree that that's an appropriate next step, or if anyone has any questions or concerns about taking that next step. All right. Well, hearing nothing, I think if Eleanor and Bill are agreeable to helping to take that laboring oar and work on fleshing out the analysis and having that presented to the committee to then have a further discussion about whether to turn this subject into a full-blown opinion, to me that seems like the next logical step. Mimi, Andrew, any logistically, does that work process-wise from your perspective? Or do you have any suggestions or alternatives?
No, that's the next logical step. It appears there's meat to chew on with this one, and just my own just general observation guidance. I mean, these are the type of opinions that really put COPRAC out there at being at the forefront. Yes, there are a few opinions that address this topic, but cryptocurrencies only continue to grow, and selfishly, I'm overwhelmed and don't know much about it. So I would very much look forward to learning a lot about that topic, when the final work product is completed. But I think it would be great, especially from the state of California, where so much of this technology resides. It's really it's right in our wheelhouse, and I would encourage us to go for it.
Yeah, that's a great point. So we'll do that. We're at noon, and I'd like to keep to the lunch hour and come back at 1. We have a few agenda items that we absolutely must get to today. So, assuming I don't get a virtual shoe thrown at me, what I'd like to do to give everybody the heads up is finish the discussion of issue outlines, which is one more. It's the one regarding flat fees. I assume, like with cryptocurrency, that's only going to take 10 or 15 minutes. And then I'd like to get to the 2 agenda items that we have to get to today, next in order, which would be paraprofessional rules and then topics for the symposium. And then from there, we'll see how much time we have left and continue in the order as was originally intended. But I think that we need to make sure we get through those agenda items today, if that's okay with everybody.
Justin, without receiving a virtual shoe thrown from you, may I suggest a slightly shorter lunch than an hour, whether it's 45 or 40 minutes? The only reason I'm offering that is I do feel we have a lot to get to today, and I'm worried that a full hour might, not because it's my last meeting and I want to get hear everything I can. Truly, there is a lot to get through, including potentially the district attorney item. And if we could save 15, 20 minutes, I think that would be helpful for the.
How about 12:45, everyone?
Sounds great.
All right. See you back here.
Thank you.
I totally understand. Oh, that was a nice touch, maybe. Well, great. Assuming there's nothing else to discuss at this point, I think it's in good shape, Ken, and it seems like that refinement's happening, and those hypos are getting there, and I think it'll be great for the committee to look at the next iteration with the fulsome hypos and analysis to give feedback, because I think you're ready for that. It's far enough along.
Yeah, if anybody has any comments, I mean, you can share them offline on the disclosure issue, because that's something we kind of struggled with internally, because the rule, the current rule, not the new rule, basically seems to put out a minimum, but we didn't think necessarily covers what you need to cover. So we were kind of broaching, and I have that in there, a bit more than the basic requirement that's in the rule. So if anybody has any thoughts on that, feel free to send them to us.
Thank you.
Okay.
All right, well, why don't we then turn to the paraprofessional rules? And I think it'll be helpful before we launch in just to have Andrew give a little refresher for those who were not the volunteers on this exercise as to what this is about. And just before he does that, gives us a little background, I'll just remind everyone the reason we're taking this out of order is because we're wanting to ensure that we can finalize our public comment letter before the deadline in January. So we'll have one more meeting to discuss our comments substantively. And so as I see it, one of the purposes of today's meeting and going through these rules and focusing maybe on the more tricky proposed rules is to get the group's feedback, have that in one place, and then the volunteers who've been working on this will help us to massage what we have into a draft letter that we can all review and provide input on in January. So that's kind of the procedure that we're trying to follow here to make the January public comment deadline. So with that, before we launch in and talk about these rules, Andrew, if you wouldn't mind giving us just your 2 cents or some refresher background on what these paraprofessional rules are about and why we're going through this exercise.
Sure. So as I'm sure many of you are aware, there's State Bar created a paraprofessional working group to create a new licensee within California to be able to provide limited legal services. As part of that effort, they want to develop rules of professional conduct for paraprofessionals. And the approach they took was to start with the attorney rules of professional conduct that were made operative in November 2018. And as a default, have those very same standards apply to paraprofessionals unless and where necessary to make to deviate or to make a change. And so before the committee and the working group undertook the effort to review the rules, I provided a chart which identified the rules that made no or minimal changes, and then those that provided some more significant changes. And after talking with Justin and Sarah and Dina, we all agreed that it would be helpful, regardless of whether there are significant or minimal changes, that the committee should put eyes on each of the rules. And I think that that is a wise approach. It'd be helpful to the work product of the paraprofessionals, as well as reflect well on this committee to say we looked at every rule and offer comments. And so the committee can best help the paraprofessional working group when they review comments submitted on their rules by identifying changes or approaches that are either incorrect under the law as we understand it, ethical law or common law generally, or statutory law, or might present a bad policy choice or might create unintended consequences based on everyone's well-known background in legal ethics generally. And so with that as background, the working group, Justin, you could probably speak to the working group's process better than I, but I think the working group divided the rules amongst each of the persons, and everybody's provided comments, or each working group member has provided comments on those rules that they deem should either be commented on or they have questions about. And again, these are rules like the attorney rules, which would set forth minimum standards of discipline. So there would be a disciplinary process for paraprofessionals, and these rules would function in the same manner in which attorney rules of professional conduct function.
That's right. And so as an initial matter, Eleanor, Elizabeth, Cassidy, Toby, and myself split up the rules evenly and made an initial pass with comments. And then we met as a group and went through all of the rules together, getting one another's feedback on rules that we didn't take the spearheading of initially. And so these comments reflect our sort of collective working group thoughts. They still need to be, in many cases, massaged, revised for purposes of a letter. But you'll see, there are a few different types of comments. One is just stylistic or grammar. Two is, we don't think that the wording was appropriate or needs to be properly modified to be focused on paraprofessionals. And then there's the more substantive type of comments, which I think we're all more interested in focusing on for today's exercise, where we have concerns or questions or proposed modifications to the substance of the rule for one reason or another, as you'll see as we go along here. And what would be most helpful, of course, anyone in the working group, if you see have other thoughts or comments on any specific rules, but that would be, of course, welcome and helpful. But for those of you who are not in the working group and haven't had a chance to weigh in, we really are interested in your feedback and additions or disagreements, for that matter, with what we're proposing in these draft comments. And when I say comment, I mean for our public comment purposes, not a comment to the actual paraprofessional rules. What I was thinking we would do after speaking with leadership and Andrew and Mimi is to go through the rules in order, so we kind of keep a process here. And if nobody has something further to say, we'll move on to the next one. But when we hit one of the rules that is a little more thorny or has more questions in at least the working group's view, I want to stop and give folks a chance to really think about that rule and get comments, even if maybe a few seconds in we don't hear any feedback, because those are the ones where I think we can offer the most assistance. Some of these are arguably not controversial, but others are maybe pushing the envelope or require further thought, at least in the working group's view. So with that, unless anyone in Andrew, Mimi, or the working group wants to say anything further about this, which I welcome, we would just start plugging away here through the rules.
Sounds good. My only observation is just, again, that of time. And so I just encourage the members to focus on big level things, major showstoppers, and not little nits. It's not to belittle any comments or concerns, but if we're going to focus time on discussing things, let's try to utilize the time for big ticket items the best we can.
Yeah, and just piggybacking on that, if any of you have gone through these proposed rules meticulously and have grammar type issues, spacing issues, things like that, send me an email, Andrew an email with those, and we can circulate those to the working group and get those types of edits incorporated into our draft letter. We don't need to necessarily spend the time now on that, but certainly we want to offer those comments in our public comment letter, just to, they might seem small and minimal, but it really shows the thoughtfulness that we've put in here, and obviously any final product, we want to help facilitate it being as perfect as possible from the grammar, stylistic, tone perspective. So that's what I would suggest in terms of those types of edits. So with that, why don't we start going through this? Does anyone have any further thoughts, comments, or disagreements with respect to Rule 1.0? Okay, and I'm going to keep going until we hit one of those more thorny rules that we want to stop and make sure everybody has a chance to give feedback on if they have it. So hearing nothing about 1.0, I'm going to move to 1.1.
What about 1.0.1?
Did I skip a page? It's not in this. Oh, here it is. Sorry, I missed it. 1.0.1 terminology. Okay. How about 1.1? 1.2? 1.2.1? 1.3? 1.4? 1.4.1?
Sorry, yeah, I just saw a typo in the third paragraph of 1.4.1. I think after the reference to paragraph A2, the prospective lawyer may need to hire a lawyer, but we can just deal with that later.
In 1.4?
Yeah, wait. 1.4.2, I'm sorry. Did I jump the gun on this?
That's okay, but we're there
Okay.
now.
Yeah. Sorry about
So
that.
where, can you say that again?
Yes, in the third paragraph of the comment, when it quotes the rule at the end, it quotes paragraph A2. It says the prospective lawyer may need to hire a lawyer or other. I think it means the prospective client, right? Is that correct? I don't know. We can check.
That's in 1.4.3. I had the same one, but
Am I looking at, oh, I'm sorry. I got off on my printout.
No, but that point applies to 1.4.2, our comment there. I see.
Okay.
Yeah, and Mimi's got it. That's great.
Okay.
Anything else on 1.4.2? So, I mean, this is one of those that I'll just stop for a moment. You know, the working group, I think, generally had some question about the requirements, prerequisites that hoops, one might say, that the paraprofessionals are being asked to go through before in an engagement with a client is even consummated. And one of the concerns being, would that be a deterrent to clients or a trap for an unwary paraprofessional who's not a lawyer, in terms of putting too much of a burden on them to make certain disclosures, either before the engagement or in connection with an engagement agreement. And so I just want to offer that as, you know, one of the concerns that struck us as we were going through some of these rules that talk about what notices must be given, including here in 1.4.2 to a prospective client, which is, you know, arguably more than what a lawyer, or is more than what a lawyer would have to do. So let me just pause there. Does anyone have any thoughts on how we've approached that concern here, and whether or not you agree or disagree with how we've approached that concern?
I had a question, and maybe it's covered later with in the advertising, but the comments to attorney advertising, when it talks about language, it talks about provide the contract in the language used in the advertising, rather than this preferred. And I just wondered where preferred came from.
Well, I don't know where it came from. It's certainly a word choice that we flagged as having questions about. I don't know if Andrew, if you have any insight as to where that particular word choice arose or how it arose.
Oh, we're talking about preferred language?
Yeah.
I don't recall specifically.
Well,
no, yeah.
Yeah, go ahead.
I'm not sure. It might.
I mean, that might come from in the
statute.
Yeah. In the fee area, there's a statute on that that, you know, specifies that if, you know, the agreement was, I think it might apply to some other contracts too, but if the agreement was negotiated and it lists a number of languages, then the fee agreement has to be provided in both English and a verbatim translation in that language. I think the English is the official one, but, and you know, and it's I mean, that's not really in any of the fee rules. It's a statute. It struck me as might be something better just to amend the statute to include paraprofessionals, but I think that's probably where that's coming from. And it didn't talk about a preferred language. It was specifically a situation where it's negotiated in that language. If you're, so I mean, it wouldn't be preferred. It'd just be, it's whatever language it was that you discussed it with. I forget what the statute is off the top of my head, but we could parrot that language.
Is that a statute could you, it doesn't have to be this minute, but could you locate that statute just so we have it for reference?
Yeah, it's like in 1600s of civil code, but I'll find it.
Yeah, but then
Cole
also,
might have it.
Ken, while you're digging that out, why don't you dig out the comments to the advertising section, which require the contract, or it might even be in the advertising rule for attorneys, that the contract has to be in the language for the advertisement. But also, I agree with the comment that preferred language is really kind of a term that's fraught with some difficulty. In other words, the client could come in there and negotiate a contract with you in the paraprofessional, all in English, and then when something goes wrong, says, "Well, I preferred French." It's just kind of fraught with potential problems that could be solved by copying the language of the rules affecting lawyers.
Yeah, I think that comparing this to the rules that apply to lawyers and what's in the civil code that Ken's referencing might help us provide some alternatives here. I don't think this is an example of an issue that we flagged but didn't necessarily come up with a recommendation. So I think having these other tools available to us, comparing it to the lawyer rule and the civil code, maybe this is one where we'll be able to add an actual recommendation.
And that kind of brings up another question I had. Overall, do we know if there's another jurisdiction which attempted to take the rules applicable to lawyers and make them applicable to independent paraprofessionals in any other jurisdiction? And if so, how did they do with this? Have we made any comparisons? I just wonder if that's out there.
Andrew, I can't remember if you looked into that or someone else did, in terms of other jurisdictions that have paraprofessionals, if any. Does that ring a bell for you?
Sorry, I was muted. I didn't look into that. I think the working group may have considered those rules, but again, their approach was to use the California attorney rules of professional conduct. So they start with that language and only deviate when they feel it's necessary. So I don't think that they looked to set the standards based on the rules for paraprofessionals elsewhere, rather to elevate the paraprofessionals' duties and responsibilities to that of an attorney, unless a deviation is necessary.
Going back to the language of preferred language, and I don't mean to get us off track for going down a different road already, but I know that in the evidence code, there are provisions that discuss when an attorney takes over a matter that's in mediation, and there are restrictions on confidentiality. If you look at evidence code section 1129, and then you go down to subsection C, and it's talking about a printed disclosure and the requirements, it does use that preferred language. Unfortunately, there's not a lot that you're going to get in terms of interpretation as to what that means, but I know that there are provisions in the code governing kind of those relationships that do use that preferred language nomenclature.
I was just doing the quickie research here. Yeah, it's Civil Code section 1632. which generally provides that where the fee agreement is negotiated primarily in Spanish, Chinese, Tagalog, Vietnamese, or Korean, the attorney must deliver an unexecuted copy to the client in the language in which the agreement was negotiated before the client executes the agreement. There's some exceptions in there. If the client had their own interpreter, you don't have to do that, but that's the code section.
Well, one might argue that the rule goes a step further than what that code provision would call for. And so maybe we need to consider whether we think that's appropriate to go a step further as this does, and maybe create more of an ambiguity than what's in the code provision, and consider how that informs any recommendation we might make in terms of changing this language. So why don't we flag that as an action item here, is to determine whether we can make a recommendation and perhaps use these code provisions that Hunter and Ken have cited in the lawyer rules to inform a recommended change. If we believe that a recommended change to the preferred.
What was the other statutory one that they mentioned earlier having to do with advertising?
Joel, what were you? I think that was you talking about one of the, was it the advertising or solicitation?
No, it's the rule of professional conduct on advertising. I can't remember if it's the actual rule or it's the in the comments section. And I don't have my rule book in front of me, and I'm too old to remember the new numbers yet. But
I can search it.
I know there's a provision which says that if the contract is negotiated, if the advertising is in a certain language, then the contract has to be provided in that language. I don't recall if it specifies the 5 languages or whatever that Ken mentioned in the 1632 section, but I do.
I'll find it.
Okay, and then Hunter mentioned evidence code 1129.
That was the other one. I was like, evidence code 1129.
Okay, that's great. That's very helpful comments, everyone. One of the struggles we had is, both because of time constraints and not having the full context of what the paraprofessional working group, the origin of their language, is coming up with recommendations as opposed to flagging concerns. So this is, I think, a very helpful exercise to take us to that next level in our draft. Any further comments or thoughts on 1.4.2?
Wait, I'm just curious. Evidence code 11, I mean, I could be mistaken. Isn't that the mediation confidentiality? Is that what you were talking about, Hunter?
Yes, and I was specifically recalling that there was language of preferred, like the preferred language in that. And because that actually did have to do with lawyer-client relations to some degree, I thought it might be helpful.
Yeah, I mean, I think it makes sense for us to explore all avenues here to see what we can come up with in terms of a recommendation. So any analogous language like that, including in a mediation statute, we might as well consider. Might lead us in a helpful direction. So it's good stuff. Okay, well, why don't we move to 1.4.3? I think this is another one that is on the thornier side. So I would encourage everyone to take a quick look at this. And while you're doing that, I'll just explain why in a nutshell. As I said before, there are additional disclosures or requirements for informed consent placed on paraprofessionals in these draft rules that don't apply to lawyers. And to give you an example here, you see in A2, giving a disclosure the mandatory disclosure of other available choices for obtaining legal services. So, I mean, can you imagine as a lawyer having a mandatory obligation to tell your prospective client, you have other options besides me. You don't have to hire me. You know, go down the road and see what's available. I mean, I'm being a little light about it, but you know, these are impositions on the paraprofessionals, and the question is, are they appropriate? Are they necessary? Are they helpful? Are they protective of the potential clients who paraprofessionals would service, or are they confusing and going to be a trap for the unwary paraprofessional? These are the questions that we were grappling with as the working group, in terms of whether all of these disclosures were clear, whether they were necessary or appropriate. And so that's my nutshell view of this in our what we struggled with, grappled with. I would welcome any additional thoughts or comments that folks think that we should consider here for 1.4.3.
Is there a policy preference that we want people going to attorneys as opposed to paraprofessionals? Because if there is a public policy that would prefer legal advice and services through lawyers, then I think that the requirement of having clients be informed of, you know, free legal services from lawyers might make sense. If that's not the policy, at least this requirement would seem to suggest that is the policy. There's no preamble to this, so it doesn't really, I don't see anything enunciating such a policy. And it doesn't really seem, I can't infer that from 1.0 either.
Hunter, I don't know this for sure. This is just my sense. I'm not sure that there's a policy for having folks receive legal advice from a lawyer per se, but I do think, again, I don't know for sure, but it's my sense that this working group, part of the creation of a paraprofessional licensee is to have a lower cost alternative to a lawyer. So you can come for a discrete legal service, you can come to a paraprofessional to receive those legal services that they might not otherwise get from a lawyer because it's simply too expensive for a lawyer. Not enough lawyers would provide those services. And I think what this is trying to get at is to, whether it's right or wrong, is to further inform the client that you might not even need to pay the paraprofessional, but there might be a free legal service somewhere else, or a limited scope legal service. And whether that's, again, right or wrong, but I think it's more information providing to the client in this example, to let them know that there might be other options available, whether that's the right approach or has economic interference concerns. Not sure, but that's the policy as I understand it, Hunter, not to direct them to lawyers per se, but to inform prospective clients who are coming to paraprofessionals for a reason, probably assumed to be because they can't otherwise afford a lawyer, or their legal issue does not otherwise require the services of a lawyer, to help inform them that there are other alternatives as well, not just a paraprofessional that might be able to help them, a lower cost alternative.
You know, in that sense, this kind of seems similar to BNP 6147, which requires you inform the client that the contingent fee is subject to negotiation and is not set by law. It's got that similar, and you read the, I can't remember the name of the case, but the case about 6147, which holds that that's an absolute requirement. It's not, can't be waived. Talks about the policy behind that is to make sure that the client is not taken advantage of by thinking that this is set by law. So I imagine there's some of that thinking in there. But beyond that, I don't think much of it, one way or the other.
I think I may have been reading more into kind of the first two: free consultation with a lawyer, limited scope services from a lawyer. Because I think that pointing out that there are lawyers, I think pushing them towards lawyers who could provide the same low cost services might make sense, because I think if there is a preference, right? If the policy is to make sure they can get the legal services they need, right? If this is about access to justice, and that does seem to be the policy being served, if it's about access to justice, that makes sense. I don't know that requiring paraprofessionals to essentially tell them about cheaper services of the same variety makes sense.
Yeah, this is the one I struggled with the most here, A2. And as we're discussing it, one word that troubled me that lawyers love to use is the word including. And in a context of an ethics rule, I find that word to stand out to me, especially when you're talking about mandatory disclosures, because including implies this is not everything that you must disclose in terms of available choices. And so to me, if the point of this subsection is to make known to the potential client that there are other options for legal services that might be free, and that's important because those who might seek a paraprofessional might not have certain financial means or otherwise. Okay, but the use of including, in my view at least, creates ambiguity as to what is the scope of this disclosure. And if we're going to put a disclosure, a mandatory disclosure obligation on someone who's actually not a lawyer, right? I think it should be clear and specific, and it should be confined so that that paraprofessional can ensure that he or she complies. And as I'm looking at this, I don't think we touched on the use of the word including and whether this should be more narrow, specific, and confined if it's going to be included. But to me, I think that might be an important consideration here.
I was thinking the same thing, Justin. That bothered me in a sense, but I think if we're going to do something that you want to be narrow, then it seems to me we have to identify all possible alternatives. It seems that's where the thicket is going to be in that type of language. If we say disclosure of other available choices for obtaining legal services, including a list of a couple of the alternatives, it seems like it should be including but not limited to these, because there may be other alternatives that are not identified in there, although I can't think of anything at the moment. But I would hate to have the paraprofessional identify these and there be another alternative that wasn't disclosed, and now that subjects he or she to some type of discipline because they didn't comply. That wasn't a complete disclosure. So if there's a, I don't want to say looser way of providing that, or suggesting that there be disclosures that simply say something, there are alternative choices available, and maybe not use it including, but say such as A, B, or C. But I would hate to suggest or imply that these are the only alternatives available to this potential client. And there may be others that are not.
And I think that actually kind of underlines what I think Justin is getting at, which is we're putting the onus on paraprofessionals to identify pretty much every single potential. And here, making it worse is it doesn't say including these things. It says including the potential availability, which makes it even more difficult for a paraprofessional to suss out all of those things that are mandatorily disclosed. So I think loosening up the definition, saying, hey, these are some examples, would actually make the burden on the paraprofessional much more arduous.
I was just looking at the, because I was kind of curious, I was looking at the public comment, what was posted on that, because it's got the proposed rules, it also has standards and some other things. And in the description of this, it talked about how the public will be protected. You know, the disclosures and informed consent are required and practitioners will need to disclose, and it's got some bullet points, but one of them, it says it's going to need to be disclosed is that free or low cost services may be available. So it seems, I don't know whether seems like that was intended in whatever is enacting this, either through standards or is there going to be, Andrew, I don't know, is there going to be something similar to like the B&P code section, you know, for paraprofessionals, or is there some enacting legislation for this?
Yeah, that's the proposal. There is there's another document that's been drafted by the Office of General Counsel that identifies potential statutory changes that would need to be made should a paraprofessional program be created.
Oh, okay. Because this seems like they, you know, just from reading the public comment description here, what it seems like that type of disclosure is something they want in there. So I guess, you know, the scope of what they disclose, you know, might be an issue, but it seems like it's intended to have that in there.
Yeah, well, and that dovetails with another overarching issue we have considered as the working group, and that is some of these rules seem to come right at the edge and arguably go over the edge from professional conduct and ethics versus dictating contract terms, right? And so, you know, how does the paraprofessional working group, you know, what is their kind of argument for A2 really being an ethics issue, a professional conduct issue, as opposed to just a good public policy that they've, or you know, believing that it's appropriate to dictate contract terms or disclosures that aren't related necessarily to ethics, because there isn't necessarily a statutory scheme in place where this might be more appropriate. And so that's a further tension here that I don't think we as a committee can resolve, but at least flag for further consideration for the paraprofessional working group, who might have more information about the proposed statutory scheme and might then consider whether some of these requirements are more appropriate for a context outside of professional conduct rules. And that's another tension I have with A2. Anything else on 1.4.3?
I had a question about, it's not on the screen now, so let me just pull up my version, about A5, the existence of any financial arrangements leading to the representation the licensed paraprofessional has with others. I realize comments have been reserved, but I'm just not clear of examples of that. And I know we have a separate 1.5.1 about fee sharing or fee divisions. So I'm just questioning, what are some types of financial arrangements that would have to be disclosed under this subsection? It's not to me.
Yeah, no, that's worth adding. I mean, it says any financial arrangement, okay, related to the representation, but with others, I mean, I think that probably means, you know, other paraprofessionals or lawyers in law firms or things like that, but it could be more clear. And if it's not going to be touched on in a comment, even if it is, you know, they could be more specific here because it is kind of vague. So maybe we want to consider in our comments, noting that if there's the ability to be more clear and specific with A5 as to what they mean by financial arrangement and what they mean by others, that would add clarity to the rule. Does that make sense?
Yes, I think that would be helpful. Thank you.
All right.
The dog agrees too.
That's my dog. I apologize.
All right, why don't we move to 1.5?
I actually had a question about 1.5 that doesn't relate to the comment necessarily, but does 6147 or 6148, do they apply to paraprofessionals? Are they, where do those, because there's a whole, set of billing requirements. And I'm just wondering if that applies to paraprofessionals too. Do we know?
Well, that's part of the question here though, because it would apply to the extent the paraprofessional is employed by a law firm, right?
Right.
But I don't know if on its face, 6147 and 6148 would not apply to paraprofessionals, right? So
No, I agree. I'm just wondering if there's been any talk of any such rule or application of those rules to paraprofessionals.
Yeah, I mean, that was our confusion as well, is that how did, there's other standards that need to be fleshed out that can't be addressed by these rules, like the statutory fee provisions that govern lawyers.
Right.
So if you look at rule 1.5.2 or 3, not sure which one. Can you scroll down to 3 if there is a 1.5.3?
Doesn't have a 1.5.2.
Okay, so 1.5.2, no, 1.5.2, I think is the attempt to bring the statutory obligations that you're referencing that are in 6148.7 and 6148 into this rule of professional conduct. So 1.5.2 is not a rule that applies to lawyers. It's a new rule that would apply to paraprofessionals. Addresses the written fee agreement that must be executed between the paraprofessional and the client. And many of these subparts are what's found in 6148.
Right, but the 6148 requirements as to like what the invoices need to contain, I didn't see those in here unless I missed it.
Right. No, you might be right.
Okay.
And so then there is that question of Office of General Counsel's analysis of necessary statutory changes. Honestly, off the top of my head, I don't know if 6148 is one of those. I would imagine that it is. There'd be recommendations to the legislature to amend or add a statute that mirrors those obligations that apply to lawyers, to have them apply equally to paraprofessionals. Which would then beg the question as to whether or not you might need this rule, if that's the case. But they want a place of discipline. And then also, getting a little off topic, but somewhat related, another recommendation of the working group is to amend the Mandatory Fee Arbitration Act to include paraprofessionals, so that disputes over fees and costs between a client and a paraprofessional would also be subject to mandatory fee arbitration as it applies to lawyers.
Any additional questions or comments on 1.5?
On 1.5.2b.
But we're not there yet. We're going to get there.
Oh,
just on 1.5, fees for legal services. All right. We'll get there soon, I promise. How about 1.5.1 fee division? Anybody have any additional comments there?
So this is a big one, in that it's a deviation. I guess, does everybody understand what the rule is trying to do? There was great concern about sharing fees between lawyers and paraprofessionals. So Mimi, I don't know if you're able to scroll to the black letter text of 1.5.1. So 1.5.1a addresses the sharing of legal fees between paraprofessionals. And then B is a flat out ban, which says a licensed paraprofessional and a lawyer who are not in the same law firm shall not divide a fee for legal services. And they discussed this at great length. There might be situations in which a paraprofessional and a lawyer might team up and assist a client on the same case. And that is still permissible, but in that example, pursuant to B, the approach would be lawyer contracts separately with the client and bills the client, and paraprofessional contracts with the same client and bills separately the same client. So that's that. And 1.5.1a, you know, the issue here is some paraprofessionals might be licensed to do certain things and not others. And so maybe you could tag team with another paraprofessional to provide more comprehensive services to the lawyer, I'm sorry, to the client. But if you're going to do that, it adopts the ABA standard of fee division as described under A2. So if you're going to share fees, that must be in proportion to the services provided, or the paraprofessional has to assume joint responsibility for the representation. And that would come up, that would be an issue if some of the services being provided by the paraprofessional were in an area of law in which the other paraprofessional is not able to provide those legal services. So you couldn't assume joint responsibility for an area of law in which you're not able to provide legal services. So that would be prohibited. So there's a lot of nuance to this rule. I'm not sure I've described it effectively for you all, but that's the approach. You look at A, that's the standard for sharing fees amongst paraprofessionals who are not in the same firm. B is a ban between quote unquote sharing fees between a paraprofessional and a lawyer. However, as discussed amongst the paraprofessional working group, they would not be prohibited from contracting separately with the client and billing separate and apart from each other. And then 1.5.1A3 is the same standard that applies to lawyers in terms of disclosing who is who and who's getting what, and obtaining the client's informed written consent.
Well, seems to me that the nuances that you described will be great for a comment to 1.5.1, and we hope that the working group for this paraprofessional rules considers that, because that's helpful to have as, you know, explanatory to this language. Thank you.
Well, I have another comment on 1.5.1, and that is 1.5.1b. If you think about it, you know, the case law at least drives an attorney who doesn't have a particular expertise to seek out another attorney who does. And 1.5.1b really would seem to be a disincentive for a paraprofessional to seek out an attorney to make up for some lack of expertise or beyond scope of limited capabilities that the paraprofessional may have. And it doesn't have any wiggle room about unless disclosed to the client or anything like that. And I think that's sort of a disincentive to silo the paraprofessional and not necessarily and prohibit, if you will, them going to a lawyer and saying, hey, I'll split the fee with you if you help me out in this one area. And it just doesn't say even if disclosed to the client or not disclosed to the client. I just find that to be a disincentive that works against the interest of the client.
So you hit the crux of the issue, Joel. They debated this extensively. Moran versus Harris permits lawyers to refer a client to another lawyer and receive compensation for that and not have lifted a finger to do the work of the case, called a bare naked referral here in California. The ABA model rule does not permit such referrals. But there was concern that, again, going back to the point, I'm not saying I agree or disagree, I'm just sharing the conversation as I recall it amongst the working group. There's concern that paraprofessionals will be limited in their license. And so if you come to the paraprofessional for their limited license, but there's a big PI claim, some folks had concerns that the paraprofessional might feed those clients to another lawyer. Otherwise, you're right, get all the disclosures. And then would that be an impermissible sharing of fees with a non-lawyer or a non-licensee on the other side, which would be the lawyer rule in those circumstances? So if you wanted to do that, it would have to be limited, potentially be limited to, you could get a bare naked referral under Moran versus Harris only in those cases in which the paraprofessional is referring a case in which the paraprofessional is licensed to provide legal services to a lawyer. It just gets it has the potential to get a little hairy. So I might not be capturing the conversation entirely correct. But that's generally some of the concerns that the working group had about sharing legal fees between paraprofessionals and lawyers.
Well, okay.
Again, I'm not trying to persuade anyone. I'm just relaying conversation as that.
No, having the context of why some of these rules are written the way they are, that you can provide. Another example of your why we love you so much. So thank you, Andrew. That really is actually helpful, and that's the type of color as we go through these that I think is going to help us focus our comments. Anything else on 1.5.1 before we get to one of the other big ticket ones? All right, 1.5.2, written agreement to representation. So I think as Andrew alluded to, there's a whole host of requirements in the written agreement that seems to try to imprint some maybe requirements that you might see in the BNP code for lawyers into a professional conduct rule, because there's no statutory scheme at this point for the paraprofessionals. And so you can see in our draft comment some concerns about all of these requirements that are being imposed on paraprofessionals in their written agreements to representation, and whether this is all necessary or appropriate. And this is one where we'd really welcome any further thoughts and comments that you have, including if you disagree and you think that all of these requirements are appropriate. To give you an example, one of the requirements is to provide an estimate, basically a budget, as part of the written agreement to representation, right? I'm looking at C, which is obviously not something that lawyers are required to do. Is that a professional conduct issue? Is that an ethics issue, or is that an effort to include, you know, additional requirements on paraprofessionals that really don't kind of fit with the purpose of this rule? I asked that kind of rhetorically as one example, and would welcome hearing from anyone about what they think and other comments they'd like us to make here.
Well, one could argue it's an appropriate consumer protection objective, considering the context. The purpose of this is so that the consumer of legal services would have a low-cost alternative to go to a paraprofessional in matters where that paraprofessional is licensed to save money. And so requiring some kind of estimate or forewarning as to what the consumer is getting themselves into doesn't seem entirely unreasonable.
Yeah, I see what you're saying, Joel. My concern is making this kind of a subject of discipline. You know, what happens if how do you figure out what is a reasonable estimate? Budgets are always subject to change. It's really hard to predict at the outset of representation. I mean, maybe easier with when it's the limited scope here, but it seems that this is not really something that is easily defined, I guess, that could be subject to a rule of discipline. I understand clients many times ask for budgets and attorneys provide them, and it just seems like something that shouldn't be subject to discipline, you know, unless it's something that's false or misleading. But if it turns out to be wrong, it just seems like there could be enforcement issues. And
well, taking the devil's advocate on that, I don't see the paraprofessional and the attorney in terms of making this kind of reasonable estimate in the same position for the reasons I just stated. But also, what your concern seems to me it can be solved by any estimate, which says this is an estimate only, and it's subject to change. And I see it, if you're creating a vehicle for the consumer to obtain what are currently lawyer-provided services by a cheaper alternative, that you do provide for some way for the consumer to gauge if it's really cheaper, and that would be an estimate. So,
you know, to me, I hear that, but a written engagement agreement, just in my own practice and experience, to put a budget in there is really impractical. I have no idea when I sign up a client how much it's going to cost to help them. Usually a budget or an estimate comes after you gather facts and information. And sometimes that information is in the hands of third parties that I have to go subpoena. So it might take a month or two before I can really even get my hands around, you know, how expensive this case is going to be. So to put that, you know, yeah, you could have caveats and say this is just an estimate, but to put that in an engagement agreement, at a minimum, to me, seems premature and not the right location. I mean, if there's a desire from a consumer protective standpoint to make sure that you know, these folks who are going to paraprofessionals because there might be cost prohibitions on what they can afford, or you know,
well,
wanting paraprofessionals to give budgets is it's like a nice practice pointer, and it's consumer protective. But I struggle with how it's a professional conduct issue that could subject a paraprofessional to discipline, or why this is the right vehicle to have that potential. And again, not having the rationale of the paraprofessional working group for including this and some of the other requirements in the written agreement that they've, you know, superimposed from the Business and Professions Code I struggle with why all of this is appropriate for a professional conduct rule. And I'm not saying I don't understand it. I just query whether we think all of these are appropriate, or whether, to Sarah's point, we should be flagging for the paraprofessional working group the concerns, and then they can decide if they should either subtract or revise some of these. Because I think the point that budgets are hard to predict at the time that you sign up your client is a good one. And I don't know the background and experience of the working group on paraprofessionals, but I think it's, we want to make sure we're giving them our experience in these areas, and make sure that they can make it,
Well, one last devil's advocate point, and then I'm going to be quiet. What makes an attorney's estimate problematic is that an attorney takes on the whole legal issue, including legal issues that the client might not even present, say under Nichols versus Keller, where you have to anticipate what else they might need. The paraprofessional will be taking on a discrete aspect of the legal issue. And I think similar to, I'm not offended by having for a consumer to receive an estimate of what they're getting into for the specific discrete service that the paraprofessional is only licensed to provide. I'm done.
In my view, I think that provision should be taken, that phrase should be taken out. We're saying that there should be a reasonable estimate of cost. I don't think it's realistic. I mean, like you said, Joe, I said, like Sarah said, it's just, I know that we used to, in our fee agreements, we would put there, the hourly rate for the partnership, or associates, whatnot. And then right after, I said, we do not guarantee, make no guarantees as to how much it's going to cost for this representation. I mean, that's a complete opposite of making a paraprofessional give an estimate. So I think that, my 2 cents is that should actually not even be in that rule. It should be what the basis for the compensation and hourly fee, flat fee, or contingency fee should be all that's required, in my 2 cents.
Yeah, Andrew, because you've had dealings with the working group. Do you know what the thought process is, why they have this as a rule of conduct as opposed to something like BNP 61, 47, and 48?
You mean, why is it a rule of professional conduct as opposed to being in the statute?
Yeah, with the lawyers, it's dealt with by statute, what your requirements are and what the consequences of violating your agreement is voidable or voided.
Correct.
Here,
I think,
making it a discipline issue, which doesn't seem to fit.
Yeah, I'm not sure.
Okay. Another question, as long as we're on
other than just speculating, they don't have the statute available to them. So they want to make sure it's client protective, and they don't know if the statute would be amended. So they want to make it's not obvious. I'm fairly confident it's intended just to be client protective and to bring those things over. Whether that's right or wrong, I don't know. And then what you guys are alluding to, I think there's case law that says, violating 6148 is not a disciplinable offense for attorneys. But yeah, there's civil consequences to that.
We might want to just suggest they do, consider doing this by statute instead of by rule. I don't know if that's beyond our purview here, but.
I think you could make that recommendation or observation.
And it was on the one we were just talking about, the reasonable estimate. I'm just curious too, because it includes in there statutory fees. I'm not 100% clear on what paraprofessionals can or cannot do, but are they going to be allowed to do things that have a statutory fee attached to it? I was just wondering if that's maybe carryover language from, code sections dealing with lawyers and their fees.
I think they're allowed to do the wage and hour negotiate, wage and hour claims and negotiations over those. And I believe those have
Oh, okay.
statutory fees under the labor code.
Okay. Then the other one I had on, on B here, because I think that, that's pretty much taken out of 6147 and 6148, the general explains the general nature of the legal services. And that makes sense with lawyers. But with these paraprofessionals, if I'm understanding how this is going to work, they're going to be fairly narrowly defined of what they can do. And I don't know whether that's going to be laid out in a code section somewhere, what they can or can't do. So that, a general nature description might conflict with or may lead to confusion of what they're specifically authorized to do by statute or regulation, or however that's going to be handled.
Good point. Other reactions to 1.5.2?
I have a question about, let me just pull subsection K, which talks about any other disclosures required by the paraprofessional rules of professional conduct or the rules and regulations of the paraprofessional board. First, I'm not clear what the rules and regulations of the paraprofessional board will be and how they'll be enforced. If we have any background on that, I'd be interested. But separately, I question the need for the first part of this. I know some of the other rules talk about getting informed written consent in certain instances, which doesn't necessarily have to be in the engagement agreement itself. And so I question for the need of the first part of this, other disclosures required by the rules of professional conduct. It might create some confusion or ambiguity. And then I just wanted some additional background about what's contemplated with the rules and regulations of the paraprofessional board.
Maybe Andrew can touch on the rules and regulations piece, but this is similar to the use of other that you pointed out earlier, Sarah, in what was it, 1.4.3. It's super vague and could lead to confusion and misapplication by paraprofessionals. I think we should add that and point out that that's really broad and really vague and open to misinterpretation. Andrew, can you kind of fill us in on the rules and regulations piece?
Sure. My sense is, I don't know for sure, but this is just my sense, that there's going to be a regulatory body, whether it's, I don't think it's going to be the State Bar Court, but there'll be a regulatory process. And similar to how there are rules of the State Bar or other obligations that attorneys have to comply with, this is arguably a placeholder right now that can later be amended. But I think it's intended to mirror how there are State Bar rules that attorneys must comply with. And I'm not sure what K follows, but there are State Bar rules that attorneys must comply with in certain instances, whether it's part of the disciplinary process, investigations, or other requirements. And I think that this reference is intended to mirror that. That's why paraprofessionals is in brackets, because they're not sure quite yet which regulatory body will be the quote unquote board.
All right. This is, Andrew was right. Let me just say that because we don't say it enough. Andrew was right. This is taking a lot longer than I think at least myself would have contemplated, but that's good and that's okay. It's helpful to go through this. And I think we should, knock through this. If some of our other topics get deferred until January, so be it. So let's just keep moving along here. Let's go to 1.6, confidential information of the client. Any additional thoughts or comments on this one?
I just had a question on the necessity for E. A licensed parent who does not reveal confidential, it does not violate this rule. Does B say, that didn't seem necessary to me, because B says the paraprofessional may, but is not required to reveal. So why, I'm not sure why it then needs to say if you don't reveal, you're not violating the rule, because the rule itself says you don't need to reveal it.
Yeah, without knowing the purpose or the context of why this was included, it seems kind of redundant, unnecessary. Not redundant, it just seems unnecessary.
Yeah. That was the only other comment I had.
I'm sorry, I was looking at, trying to find some notes. What, I missed the specific comment you're making, Ken. What's the concern?
Well, B says a licensed professional may, but is not required to reveal confidential information.
Yeah.
E says a licensed who does not reveal confidential as permitted by B does not violate the rule.
Yes, that's same as the attorney rule. So it's discretionary for the lawyer to reveal confidential information. It's not a
well, I
requirement. Okay.
Because
sorry,
I don't understand the necessity for E that says, you know, B says you don't need to.
Oh, I see what you're saying.
E says if you don't do what you don't need to, you don't violate the rule.
I'm pretty sure it's intended to mirror the attorney rule. Let me look at it.
Yeah, it does. Yeah, here's.
It's just probably belt and suspenders so that no one could say, you know, the lawyer is disciplined for failing to reveal. So
maybe we should change 1.6. Just kidding.
I think
that was my opinion on that. So okay.
All right. All right, 1.7. Conflicts. Any further thoughts on 1.7 here? It essentially mirrors the lawyer 1.7. I'm just looking at the red line. Except instead of lawyer, they've substituted licensed paraprofessional. I'm not seeing any other changes really to the lawyer 1.7. All right, well, hearing nothing. 1.8.1, any comments? We had no proposed revision to that one. 1.8.2. All right.
I didn't understand that one. I mean, under what circumstances would a client consent to their confidential information being used to their disadvantage?
Excuse me.
Ken, that's the discussion we just had on the APRL website. I think the scenario was somebody comes to a lawyer who doesn't have a claim, but reveals facts that shows that there's a possible class out there that does have a claim. Can the lawyer use that information and rustle up a named plaintiff for that class using the information from the client? And there was a whole back and forth about whether that was a disadvantage or whatnot, and so on, but that seems to be the same issue.
Well, and keep in mind, this mirrors the lawyer 1.8.2, which has the language about disadvantage of the client. So I don't think we're going to gain traction on that language.
A whole CLE program could be provided on the difference between use and reveal of confidential information, but it's a nuanced issue, and it's Justin's right. It mirrors the attorney's standard.
Okay, 1.8.3 gifts from the client. Our changes were pretty minor, proposed changes. 1.8.5. One point 8.6, 1.8.7, 1.8.8, 1.8.9, 1.8.10. We had no revision. All right, 1.811 imputation. Excuse me. Let me give you a second to look at this one. Any other further comments to the imputation rule that we're looking at? Nope. Okay. How about 1.9?
I had one quick question, Justin. Sorry to back up. I was just looking at that language, and I might have overlooked something. Is there any screening option? For imputation? It just seems like, given the paraprofessional's more limited scope representation, screening might be effective in certain circumstances. And
There should be. Is there no reference to that?
I might have just missed it. I was trying to.
Isn't screening in 1.9? Are supposed to be.
Maybe I'm thinking of Rule 1.10. I might be confusing the rule.
Right.
So yeah. Okay. Sorry. I was just thinking of the screening and with imputation rule, and I guess 1.8 is different than the 1.10. So.
Yeah. Okay, we're almost there.
So hold off.
So what's next? 1.9?
Yep.
Okay. Duties to former clients. Switch up on my red line here. So again, this is essentially the lawyer rule 1.9, except substitution of the paraprofessional word and then also removal of the BMP code. And then instead reference to 1.6 instead of the BMP code. So again, the working group was trying to do what they could to address confidentiality without having the benefit of the BMP code. Any comments to this? Okay, 110 imputation. I think our comment on this one is there was some confusing language about who this particular rule was intended to apply to, because obviously, you know, the screening issues in a law firm that has lawyers and licensed paraprofessionals, you know, it's going to implicate potentially this 110 and the lawyer 110 as to whichever respective professional is being screened, and some of the language gave us a little pause there. I don't remember offhand where it was, but that was the only comment that we had to this one. Does anybody else have something to add? All right, let's keep moving. 111 or 112. Anybody have comments on 111 or 112? We didn't have any in our working group. Okay, 115, safekeeping funds. We only had some stylistic edits. Does anybody have anything substantive to comment on? All right, 116, declining or terminating representation. The main difference between the lawyer 116 and the paraprofessional one is A5, which has to do with the scope of practice of licensed paraprofessionals being narrow. So if anyone were to have a comment, it might be on that one. Any thoughts there? Okay. 117. All right, 118, duties to prospective client. Okay. 2.1. No, pretty straightforward, nothing there. 2.4. Okay. 3.1 or 3.2. Um, 3.3, candor towards the tribunal. And I think I think this might have been my comment that's in yellow. It says A3. Can a licensed paraprofessional ever call a witness to testify? And if so, there was some deleted language that would seemingly apply in that context in terms of candor to the tribunal. Andrew, tell me if I have this wrong. A licensed paraprofessional can't, you know, handle a jury trial. I think I saw that. But what about a court trial? Could a licensed paraprofessional call a witness at a court trial?
I don't think so. I'm not entirely sure.
Okay.
I don't think so, but I don't know for certain.
Okay, well, I guess that's something we can run down, because I recall specifically saying no jury trials, but
Right.
but I'm not sure about court trials.
About administrative hearings or something.
Or
like that.
administrative hearings, right? So
Yeah.
if they can, then I think there's some language to add back there that was removed, maybe you know, prematurely, that had to do with candor in the context of trial type proceedings. So that might need to get added back from what the working group cut. So we'll look at that. 3.4, we had no revisions. 3.5 is contact with judges, officials, employees. It's fairly straightforward. Any comments on those? 3.6. Three 3.7 or 3.9. 3.10. 4.1 or 4.2. So 4.3 and 4.4, we had no proposed revisions. On 5.1, responsibilities of managerial or supervisory licensed paraprofessionals. This is kind of an interesting one, and I think as our working group, we weren't entirely sure what the hierarchy would be, and how within a law firm that has licensed paraprofessionals and lawyers, excuse me, and how that would, what the interplay would be with in terms of responsibility for managing and supervising licensed paraprofessionals. So we had a sort of a question there, and that I think we need to explore further. Other than that,
I think I can chime in on that.
Yeah, that'd be great.
So I don't think there's any indication that a paraprofessional would supervise a lawyer. So if we look at the lawyer rules, 5.1 would govern the conduct of a lawyer supervising another lawyer. And arguably 5.3 for the lawyer rules might apply to a lawyer supervising a paraprofessional. That is an open question, but I think it could apply. And then with respect to paraprofessionals, I think it would be 5.1 would be paraprofessionals supervising other paraprofessionals, and 5.3 would be paraprofessionals supervising other non-paraprofessional legal assistants. That's how I anticipate the rule structuring would work. But I don't know if that was the concern you had.
No, that makes sense. I think in my own mind, I was quite frankly concocting hypotheticals that wouldn't actually in practice occur in terms of a situation where a very experienced, for instance, a very experienced licensed paraprofessional might appropriately or need to oversee some first-year lawyer, say conducting a proceeding or something like that. But I don't think that's really applicable to what these rules are covering, or quite frankly, what would actually happen in practice. So any questions through 5.3 or comments? I'm going to just move to the next one where I think we had substantive comments. And so if I go too far and somebody had a comment, we can go back. So see here. Well, why don't I do this? Because I think we've gone through, Andrew will tell me if I have this wrong. I think we've gone through most, if not all, of the ones that we kind of flagged as the thornier rules.
Yeah, I think
go ahead.
Please finish your thought.
No, I'm done.
I was gonna say 5.4 and arguably some of the revisions to the advertising rules were some of the substantive changes that remain.
Okay, so let's focus there, and then if others, had written down thoughts or comments, want to provide thoughts or comments on the ones that we've skipped, just chime in. So let's go to 5.4.
So this is the big one in that it permits paraprofessionals owning a law firm with a lawyer, so long as the paraprofessional does not have a majority ownership stake in the law firm. And then it also adds language to make clear that no paraprofessional could supervise. I forget the language, might just scroll to it, but no paraprofessional, it might be E, yeah. Paraprofessional shall not practice in a law firm if can't direct or regulate lawyer's professional judgment, can't supervise a lawyer. And then here, can't possess majority ownership or exercise controlling mandatory authority in the firm. So E1 and 2, I wouldn't think would be objectionable, but I don't know if it's objectionable, but it was the source of a lot of debate amongst the working group's discussion was E3. And as I understand, the purpose or the policy is to encourage lawyers and paraprofessionals, perhaps, to work together to provide innovative or different level of legal services to a client, depending on the client's needs.
Any further comments or questions about this one?
Is it inappropriate for us to voice more alarm at this rule change if we have more alarm? Or is our goal to just facilitate the best implementation of the planned rule?
If you have concerns and you're able to direct them to those concerns, I'm sure that would be helpful. Of course, they're a sister group of the same organization, so we'll take care to word it diplomatically. But if it's anyway, I would be curious to hear what your concerns are. I mean, of course, the committee can determine a majority vote could be determined. A majority vote by the committee could determine what content is shared.
Right. I mean, I know people have just been talking about this at length, but I am not yet comfortable with the concept of non-lawyers owning parts of law firms or being, in the same business, and that concerns me a good deal. So that's sort of the premise of the rule. So I don't know if it's productive to raise it again now.
Well, I guess if that's like your opinion, obviously you're free to have such an opinion. If there's I think it might be more productive if there was something we could direct the working group to as to why you or the full committee might have those concerns. Again, I want to make clear, there's nothing that would prohibit the committee from sharing concerns that they have about any of these proposals. I just think in order to be most productive, to support those concerns with whatever authority or references we could show them.
Right. I mean, I think the concern that I generally hear is that if there are non-lawyers who don't have the entire suite of fiduciary duties that lawyers have, that are in management positions, and we're not talking about ethical supervision, just job supervision, employing, could you have paraprofessionals that can make hiring and firing decisions over their lawyers, that it would necessarily risk compromising the independent judgment of lawyers. And I know that the working group thought about it very carefully and came to a different conclusion. I'm still very uncomfortable with it. And I just wonder what the thoughts of others on the committee here are, whether it's worth talking about it further or letting it go.
Well, I'll go if anyone has thoughts.
I mean, I had a similar concern that, once you start opening that door, I mean, it seems like they're trying to curtail, but once you have an ownership interest, I guess the question would be the weight, I mean, if you've got a paraprofessional who, let's say, is a 10% owner of a law firm, and you've got associates who have no ownership interest, are they going to, subjectively or whatever, defer to them, or the extent that I guess if the paraprofessional as an owner would have any input on, salaries of the professionals and how that could influence them. I mean, there's a whole host of issues, it seems like.
Yeah, and what about just a two-person law firm where one is a lawyer and one is a paraprofessional? And, the partners are normally have to have some sort of management authority in order for it to be a legitimate partnership. So it kind of runs against that a little bit. And it would necessarily mean that the paraprofessional would have some sort of supervisory authority over the associates if they exist.
Well, let's assume that this structure is going to happen, right, as contemplated in this rule. And this is not to put anyone on the spot, but something to think about, and maybe if there's proposed language or comments, as we work through the drafting of our comment letter, we can work on this. But so take A3, take E3. Is it, if this is going to happen, right, and but we want to suggest more guardrails. I guess the question is, what would we suggest? Hearing what Cassidy and Brandon said, I look at, with that in mind, looking at E3, I'm not really sure I understand what exercise controlling managerial authority means, quite frankly. And that seems to be one of the concerns, the control that Brandon and Cassidy are identifying, particularly over decisions. I think I heard, hiring and firing and things like that. I really don't know what that means. And like okay, they can have controlling managerial authority, but they can have some kind of managerial authority as long as it's not controlling. I don't know what that means practically. And so I at least can understand the concern that this isn't really clear about what a licensed paraprofessional who owns part of a firm can or cannot do when it comes to the management of the firm. And I wonder if that's going to be a recipe for a lot of contention about whether licensed paraprofessionals who end up in this kind of arrangement are exceeding the bounds of this rule.
I mean, that kind of touches on what I was talking about earlier. I mean, it seems to me E3, the intent there is to say you can't be have a majority ownership interest. But what if, like I said, if you're a 10% owner, what kind of weight does that give you in terms of the operations of the firm, salaries, are associate lawyers going to, implicitly defer to you because they know you're an owner? And then, I guess kind of like the situation Cassidy was discussing, if you've got maybe a 3-attorney firm with the 2 partners where the lawyer owns 51% and the paraprofessional has 49%, and then you've got an associate working under them. I mean, how does that play out?
Yeah, well, the other reason that makes sense. And this concept of managerial authority is, I'm thinking about my own firm and large firms. It's pretty vague because, for our management is mostly non-lawyers. They're not licensed paraprofessionals, I can tell you that, but they're business people who have managerial authority in my firm. So in the context of paraprofessionals, what we're saying they can't do that. So for instance, our COO, our controller, our CIO, none of those are all the people in our management. So what do they mean by management here? And management authority, and then add the descriptor controlling. This is very vague as to what a paraprofessional can and cannot do, in my view. And I wonder if that could lead to an exacerbation of some of the concerns that Brandon and Cassidy have suggested might exist out there. But I also don't know what the cure is to the vagueness of this E3, candidly. But maybe that's something that we should explore. I don't know. Am I the only one who feels that way?
No. I think it's smart. I mean, should our comment just say, potentially that we don't understand this term and it needs to be explained in a way that's meaningful to readers?
Yeah, I mean, I think that's a fair point, and it's frankly some of the the tenor of many of our comments is we're not entirely sure what you mean and what the scope of what you intend is here, and we think that this could cause confusion and period. And sometimes we offer a recommendation and sometimes we don't, but it sounds to me like at a minimum we might want to flag that what's being proposed here in terms of a restriction, it's not entirely clear what that restriction actually looks like in practice, and it could create some confusion.
And is the plan to eventually draft proposed comments to the rules as well? Because this seems to be an area where examples would be useful.
Well, Andrew's not here, so I'll play Andrew for a second.
Oh,
My understanding from Andrew is that yes, the somebody, I don't know if it's the working group for the paraprofessionals, is going to draft comments. So these paraprofessional rules are supposed to have comments. And that's one of the challenges we here at COPRAC have is we don't know what those comments are going to be and how they might actually address some of our concerns. So one thing we want to at least suggest in our own comment letter is, hey, if you weren't intending to address X, Y, or Z in a comment, if you aren't going to revise the actual rule, hey, we think that this sure would be helpful to clarify, somewhere, including in a comment.
If we haven't already, I think it would be helpful to say, we hope to have welcome and hope to have the opportunity to provide further comments as may be warranted after we see their comments.
Absolutely. And Andrew, is that, process-wise, would there be a public comment period after whomever drafts the comments to the paraprofessional rules? Is there going to be a public comment period to comment on their comments for the rules?
I don't know what the process is, but I would assume so. I mean, that's how the attorney rules went, but I don't know of a work plan or a timeline for that, but that's my understanding.
Yeah. I think Elizabeth's point, though, is good, that we should be clear in our own letter that we think it's going to be real beneficial for COPRAC and other folks who want to weigh in here to see these comments, because they a lot of what we're doing is kind of shooting in the dark because we don't know what those comments are going to look at.
And that could be a helpful statement. That could be a helpful statement in like an introductory paragraph. It applies to all of this, of course. Yeah.
Yeah, and I think it's important. It applies to any individual or organization reviewing and commenting on these proposed rules, that the public is seeing this in a vacuum, and
for sure
the quality and scope of our input is obviously seriously limited without having a full understanding of what the final product's going to look like.
And similarly, not knowing what, if any, statutory changes or amendments might accompany this, so those are all fair comments.
Yeah.
I have a comment here. I mean, it looks like they were trying to change, or just convert 5.4 in the rules to this. And they tweaked B here, but how does this rule 5.4, how do you reconcile it with 5.4B in the lawyer rules? A lawyer shall not form a partnership or other organization with a non-lawyer if any of the activities of the partnership or the other organization consist of practice of law. That seems to say a lawyer can't form a partnership with a non-lawyer for the practice of law. Now they changed lawyer to paraprofessional and B in here, but I don't see how this reconciles with 5.4B in the lawyer rules.
I think that's one of the comments we make is we say in our draft comment, maybe we need to be more clear, is that to enable implementation, parallel change of the lawyer rule will be required. So I think that we had a concern about that.
Okay.
Yeah, I do think that there is awareness that not just this rule, but there are other rules that will need to be amended in the attorney rules should a paraprofessional program be enacted.
Well, that to me, now I'm feeling ignorant about what our purpose here is in commenting upon these rules as COPRAC. Are we commenting upon these rules to give them wise guidance about how a similar organization will oversee or guide the paralegals? Are we protecting our rules versus these changes? I mean, what's our objective here? I mean,
Not sure I'm capturing your concern clearly, but I would advise the committee as ethics experts, the best help you can give is, you have great familiarity with rules of professional conduct and how they apply to attorneys. Again, the baseline is to have the similar standards apply to paraprofessionals as much as possible, and to provide any drafting assistance or legal observations or effects of the way these rules are drafted.
Going back to Brandon's comments, for instance, about how not being convinced, and I think I share some of his views about whether it would be appropriate from both a business and an ethical standard for lawyers to be partners with non-lawyers, and how much interest they should have in a firm. There might be some among our legal community who would think that some of these rules that they're talking about for paralegals might do violence to the ethical requirements of lawyers. And is that something we should be protecting, or something we should be thinking about finding ways to meld? So I'm just feeling ignorant as to just what we're doing here.
Well, I don't think any interest in being quote unquote protective of the attorney rules should be used as a reason to not allow for the implementation of a paraprofessional program. A paraprofessional program have to be condoned by the Supreme Court and probably the legislature. And so if that's the policy of the Supreme Court as lawyers, I think we should try to best effectuate that policy. And as you said, harmonizing or marrying the rules of professional conduct for attorneys with whatever the final set of rules of professional conduct for paraprofessionals ultimately becomes. But that would be a second step. The attorney rule amendments would have to be undertaken after these are enacted. So I use the word protect. That makes me a little concerned. I don't think we should be seen as quote unquote protecting the attorney rules, but if there are, major issues or concerns or conflicts that we see that are unworkable, we should bring it to the paraprofessional working group's attention now so that they can address it if at all possible. The 5.4 minority ownership issue, I mean, that's tough because that's kind of a policy call. And again, if the collective voice of the group is that there's disagreement with that, one approach could be we have concerns or we disagree with allowing paraprofessionals to have an ownership interest with lawyers. These are the reasons why. Notwithstanding these concerns, if the paraprofessional working group determines to adopt the rule as proposed, these are the edits we would recommend be changed. I mean, there's different kinds of drafting techniques that can be undertaken depending on what the position is of the committee.
Okay.
All right. Anything else on 5.4? So I'm thinking we would, I'm ready to go to 7.2, but if anyone has comments or thoughts between Rule 5.4 and 7.2, let us know now and we'll do those first. But otherwise, why don't we skip ahead? So, excuse me, 7.2 is advertising. For the most part, until you get to about subsection C, it's similar. The substitution of licensed paraprofessional in the place of lawyer. And then in C, there's added language that the communication will include the license number and a statement that the paraprofessional is not a lawyer, right? Those are the changes to C. And then D is new, that the licensed paraprofessional, if he or she has a website, it'll basically include the mandatory disclosures under Rule 1.4.2. So you can see, some of the comments that we had that it's, as I said, with C and D, it's not exactly the same. Noting that the licensed paraprofessional is not a lawyer, I think we understand why that's added. D again is, to me, having gone through this conversation today, I don't really like D as phrased because it relates to 1.4.2 A, which I have some concerns about. 1.4.2 talks about providing written disclosures to a prospective client in that prospective client's preferred language. Well, how are you going to know on your website when somebody comes and visits what their preferred language is? So there's a disconnect between what's practical and what subsection D is saying. So I think that's something we need to probably point out. It occurs to me that we haven't yet noted. But other than that, any additional thoughts or concerns?
Just following up on the point you raised, Justin, about subsection D, one recommendation that I've seen in some other laws, just if it's going to remain, if we're recommend that it be in like the 5 primary languages in the state of California or something.
Yeah.
Andrea, maybe you can answer this. What's the rationale behind having the license number of the paraprofessional on the advertising?
Again, speculating, but my sense is it's client protective to make sure no fraudsters could mislead a client. And by putting the license number up there, that empowers the client to go to whatever database is available to punch in the number and confirm that they're speaking to the actual person. That's my sense.
Okay, I assume this would include if there's, it's a paralegal or paraprofessional firm that would all the paraprofessionals need to have their license number on the advertisement if they're advertising a firm, or would the firm have their own number? I mean, firms don't have their own number. The law firm,
Correct.
you know.
I think it's each person. So there's probably more than one way to do it, but you know, you can go to paraprofessional firm of A, B, and C, go to people. Every time you click on, click on John Smith, has their number, or you go to paraprofessional firm ABC and Jane Smith, and everyone else is listed on the header and their number is under them. There's a variety of ways, I would imagine. And it's it's a discipline enforcement issue also, to find out what to do if they're not doing this. So,
right.
But yes, I think it's a public protective measure to make sure clients have a way to verify who they're speaking with is actually a certified a licensed paraprofessional.
Gotcha.
Okay. Any other thoughts on 7.2 before we move to 7.3? No? Okay. So let me give everyone a minute to look at 7.3, just to flag for you the main differences between the lawyer rule and the paraprofessional rule. Started from C2 through D2. So C2 through D2 are these additional requirements or limitations that are being placed on licensed paraprofessionals. It'd be great if anybody has any reactions to these. Some of them are similar to 7.2. The runner and capper pieces is obviously not in 7.2. Any comments or concerns about C2 through D2? No? Okay. I'm just flipping through the other rules. Our comments were fairly focused. I do think we should talk about 8.4, if I'm remembering correctly. Yeah. So, would be interested to hear feedback on 8.4 in particular. What you'll see added that doesn't exist in the lawyer rule. Give me a second so I can get this right. Is G and H. Take a look at G and H. So for G, right, it's professional misconduct for a paraprofessional to report suspected immigration status or threatened to report suspected immigration status. And then it goes on. And then H is that it's professional misconduct to advocate the overthrow of the government by force, violence, or other unconstitutional means. These are obviously two sections that don't exist in the lawyer 8.4, but for one reason or another, which we can debate, have been added here. And so, as you can see in our comment, I think we understand the concern about in G regarding immigration status, in light of perhaps the issues that might arise in the context of the type of services a paraprofessional might provide, or the demographic who might be served by a paraprofessional. And then H, but on the other hand, it is well beyond the lawyer 8.4. And then of course H, quite frankly, I'm not sure where that came from. It seems kind of out of the blue in terms of what you'd put in a professional conduct rule.
Wouldn't B cover H? I mean,
commit a criminal act.
Yeah, I mean, I don't know. Seems like H maybe is possibly directed toward current events, but.
So just to jump in, I think I tried to share this in my comments with the working group. I mentioned also previously during the discussion today that study of statutes that apply to lawyers has been conducted by the Office of General Counsel to see what potential rule amendments need to be made. And G and H are obligations of lawyers. I don't have the statutory requirements in front of me. And the working group felt that they were important obligations with respect to misconduct and the fitness of a legal professional. So they tucked it into 8.4 because those statutory obligations, well, they do apply to attorneys, don't exist right now for paraprofessionals. So again, free to debate amongst yourselves as to whether or not it belongs in Rule 8.4, but these are standards that currently apply to lawyers. And so they just felt 8.4 was the best rule to add them to.
You're saying there's a California statute that relates to G&H specific to lawyers? Or are you saying it is study around the country and some states have that type of prohibition, or can you clarify?
Yeah, hang on, let me, you have to give me a moment. I have to find.
Is it 6106.1 under the Business and Professions Code?
So 6106.1 is the advocacy of the overthrow of the government, and 6103.7 is reporting or threatened reporting of immigration status. So those are in the State Bar Act and apply to lawyers. And the working group felt that they were important to apply to paraprofessionals. But again, you're free to disagree, but that's where they originate from. And yes, Elizabeth, you got it.
That's great. That's helpful. Again, I think this comes back to we're kind of shooting in the dark. We don't know whether these G&H are being contemplated in the statutory scheme, or could be, or should be within the statutory scheme for paraprofessionals. And as a matter of parallelism, seems like they should at least consider whether it would be more appropriate to have G&H in the statutory scheme, if that's even possible. So maybe we can at least flag this as another example of that thought. Anything else on 8.4? So I know we went through some of these other rules very quickly. If anyone has additional thoughts on any of these rules, please don't hesitate to, I'll take the onus. You can send them to me and Andrew and Mimi, and I can collect them and send them all in one package to the working group that we have on this project, and then incorporate that for purposes of our draft letter to be presented to the committee at our January meeting. And then hopefully we can finalize the letter at our January meeting and have it ready to circulate for public comment. But that being said, if there's any other comments on any rule that anyone wants to raise with the group right now, let us know. But otherwise, we welcome any additional thoughts that you might have outside the context of our Zoom meeting. Okay. Well, hearing nothing, why don't we take a 10-minute break and come back? Or you know what, maybe I want to make it 7 minutes. I want to keep that virtual shoe not being thrown at me, Andrew. So 7 minutes, 3:10. We'll come back. We'll do the symposium topics, and then we should do the client file returned opinion, I believe. And Andrew, I'm going to call you at the break for a second, and then we'll see everybody in 6 minutes. All right, well, let me scroll here. It looks like we're missing one or two folks, so I'll just wait another minute.
Sarah had to step away, and Dina's been away, so I think we should be. I think most folks are here.
I'm here.
Oh, you don't want to show off your new blurred background?
My blur background.
All right, I think everyone's back. Okay, so next topic is the symposium, which is in April. But as you know, and I know Andrew will have some remarks here, so I won't steal his thunder, but I'll just say it's very helpful for us to have this conversation now about topics, so we have less of a concept crunch when we get to January and have to finalize the panel topics. Maybe for our new members, and just as a refresher, Andrew, you want to give a sort of background on the symposium and our process for selecting topics, and then we can launch into discussion.
Sure. So the Ethics Symposium is a yearly program. Unfortunately, it was canceled in 2020 due to COVID. One of my few regrets of staffing this committee is not getting the gumption together to try to do it via Zoom in time, but that it's always held in April. We got shut down at the end of March, so it was a challenge. But we held it remotely last year, and it was well received. Had possibly record number of participants because it was held remotely and not at one of the locations, the State Bar building in San Francisco or Los Angeles. Each panel is an hour and 25 minutes, so that we can get a round number of 5 hours of CLE, which is more than the required 4 that you need every 3 years. However, each panel used to be 1.5 hours to give you 6 hours of CLE, but the last hour people would invariably leave early. And so several years ago, we scaled it back to 1.5 hours. So it's a 1.5 hour panel, 4 panel topics. Historically, the symposium has, with great pride, made these high level cutting edge issues. So try not to think of your basic CLE of someone who's not well versed in legal ethics. These are former COPREC members, members of other ethics committees, law professors who teach legal ethics, people who have a great, a much well-rounded and greater foundation in legal ethics than someone who doesn't focus in this area. Typically is the participant who's interested in attending these programs and learning at these programs. And staff has I don't want to call it work plan, but a set of deadlines of when panelists need to be identified, when materials need to be submitted, when promotional activities need to take place to encourage people to sign up, and when registration begins. And so the need to lock in the panels in early January so that panelists can be solicited is part of that plan. And so this meeting is typically a general brainstorming meeting to try to get the potential panel topics. If we could get it down to 4, that's great. If we got it down, to 6, or just to kick off a brainstorming discussion so that we can finalize the panel topics at the next meeting. Also, traditionally, the panels are moderated by one of the committee members. Usually it's now a fourth year member of the committee, third or fourth year member of the committee. Doesn't always have to be that way, but past practice has been to defer to the senior members of the committee to moderate a panel, with not understanding that, you know, everyone will get that opportunity at some point. You don't have to moderate. You can obviously pass on that. And one way to increase the ability of more folks to moderate is, after the annual meeting was sunset by the state bar, there is an update and legal ethics panel, which typically is conducted by COPRAC, and that also typically, but doesn't have to be, is put on by the leadership of the committee. So those three folks would talk about, you know, the big cases and ethics opinions in the prior year to bring people up to speed on those topics, should the committee choose to do that topic. That is something that's been historically done. So long-winded description. We have a list of topics that were considered last year but not selected to pursue to help kick off the brainstorming process. We also have a list of panel topics that have been put forth throughout the history of the Ethics Symposium, so that we don't do something that was done recently, as well as to potentially reach back and pull something out that was done many, many years ago, which might be right for revisiting.
And
So
I just want to jump in and say,
Please.
in addition, we also have a list. It appears on page 2. Starts on page 2, are topics that were suggested by symposium attendees on their evaluation forms. So we try to collect those because sometimes they have good ideas, and sometimes it gives us an idea of what people are interested in.
Can you project the list, Mimi, or at least the
Doing it right now.
topics to help? Great.
So you see it? Okay. So yeah, right now we don't have any topics. Sometimes members suggest topics, but these are past topics that were considered, and we just keep a running list. And then followed by, on page 2, which I don't know why that heading is there, a list of things that have been suggested by past attendees, as well as, and then the other attachment, which is actually separate, is, oh, not that, sorry. This is the historical list, which is 22 pages long, of all the panels we've done in the past and who presented. So maybe we could start with just, did anybody like anything that they saw?
I'm curious, so this one that says 2021, this was people that went to the symposium.
Correct.
Because you know, I always, you know, coming from fee arbitration, what we used to do at the annual meetings, I always liked the billing ones. I was surprised that there were so many attendees at a ethics symposium that thought that that was something that they'd like. There's 2 or 3 of them in there dealing with bills and billing practices and liens.
Mimi, I will say that that issue in 2021, the remote billing or the future ethics issues in remote practice, we dealt with that last year. I think some of the topics for one of our panels that Justin and Steve and I did probably weren't captured based on subject matter, because we did opinions and stuff. So that was already done last year. We kind of discussed that opinion. And then the very top one on this list, where it says future things that were considered but rejected, or at the top where it talks about law firm transitions and the ABA and the COPRAC opinion, we talked about that at the last year's symposium during sort of our overview of the opinions.
Okay, I'm trying to find
so just
that
to
one.
reference that.
It's at the very top.
Oh, this one, sorry. Okay, yeah, these were just based on whether there was an actual panel dedicated to it. That's all.
Well,
this does not belong here because technically it was selected.
So why don't we just get a couple of things squared away, because I think we'll be on the same page about this. I hope. I thought that, you know, as some of you might recall, we used to, the leadership used to have a panel where we talk about, the most interesting ethics opinions, meaning case law typically, that had come out in the last year. And another organization now puts that on with their meeting, I understand. And so we switched last year to, instead of talking about, the latest and greatest, most interesting case law developments in ethics, we talked about our recently published COPRAC ethics opinions in the panel involving leadership, and then some of the kind of up and coming opinions that we were working on, and the interesting ethical issues arising out of those opinions. I thought that worked out well, and was fun to put together, and helped the public get a sense of what we've been up to recently, both in what we've published and what might be coming down the pipeline. And so, and we were also able to build in some the more traditional case law references to ethics opinions as well. But I thought the structure worked for that panel, the traditional leadership panel, but with this sort of slightly different subject matter of our ethics opinions. And so at least right now, I think that I would think that that's the approach we would probably take, and that assuming Sarah and Dina were on board with participating in that panel, that we would continue that tradition for one of the 4 panels. And does anyone have a views on that?
I'll just observe. I think Sarah had to step away.
I had a thought, I think that's always a good idea. Let people know what COPRAC is working on. But the other thought I had was, has anybody in recent memory contacted the OTC and found out what are the 3 most important topics that attorneys should get educated on, because that's what's showing up in their office? Where are these attorneys screwing up? What are those topics? Maybe that's what they need, more than what we think is really hot and new and sexy. So
we could do that. I mean, you'd want the 3 most charged rule violations, or, I mean, there was a lot of focus on client trust accounting, so they might recommend that topic.
I know that's
notwithstanding the fact that that's necessarily the most charged item. I'm not sure, or it very well might be. I know it's always been of great concern and interest to them.
Well, I don't know if it's a good idea or a bad idea yet. And I'm sure that just putting on another program on trust accounting and the ethics of trust accounting is not something that really is going to be helpful, because they do that a lot. But I would just like to see, what are they seeing lawyers needing by their conduct? And then we could take a look at that to see if they can craft some program around hot topics to be careful of. Can we get that information or at all?
Staff could certainly ask. That shouldn't be a problem. I don't know. I'm only hesitating, just speculating. I'm just worried that it might be one person's opinion on what's needed, or we could get, data. If you wanted data, then it would be what? The top 3 rule violations, the top 3 rules that are used as charging vehicles for a disciplinary offense.
Well, I'm more concerned in data, because right now I know their hot topic in terms of, for instance, training for special deputy trial counsel is trust accounting. And like I said, that to me is not something that the whole general public really needs, because there's a lot of other ways of getting that information. But I just like to find out statistically what's going through that office and see if there's anything we can do to maybe educate the general attorney population about how to avoid going through their office.
Yes, that, I mean, we can make that inquiry for sure.
Justin, I like your idea of for the leadership doing that, more of that overview of those, the opinions like we did before. I thought that worked out well, and we can kind of shape that based on what the other 3 topics are that we've selected. I was wondering, just in hearing the discussion about cryptocurrency today, whether that would be something that might be interesting for a panel. I mean, alternative forms of payment, or maybe if it's not enough for a whole symposium, like expanding that issue, but it just seemed like there's a lot of material in that, and it's something interesting that's just and contemporary and current. So I just wondered what people thought about that, particularly people that worked on that, if they thought that was beefy enough.
Well, I can just tell you from past experience, I've attended a cryptocurrency tied to legal ethics panel that I think it went about an hour. So certainly possible. And, if it weren't one of our other 3 panels, I think it's definitely one that we would highlight in our leadership panel as one of those topics potentially coming down the pipeline, because it is an interesting topic and relevant. So I could see it going either way, depending on what other subjects we might want to have in our panels and preferences of moderators and things like that. But somehow, somewhere, I think it would be a topic that we would be well served to touch on one way or the other. So I don't know that this is necessarily a topic that I would put in a bullet point here, Mimi. I was curious what people think. One thought I had is, as we were working through the paraprofessional rules and thinking about ADLs and all of that, access to justice issues and how that ties into ethics. And I can't remember, Andrew would probably remember, Mimi would probably better remember than me, but I have some vague recollection of a symposium panel that might have already touched on ADLs and access to justice issues in the last few years. So if that's the case, then maybe that's why I thought of it.
We did it 2 years ago, Justin. I was the moderator of the panel, and we talked with some folks who were on the ADLs committee and kind of discussed what they were doing, the issues they were looking at. So it was, obviously things have changed since then. They, the work of that committee, they had recommendations. Now there's the second iteration, or looking at that access to justice, which I'm sure Andrew can speak more about. I mean, the question, I guess, would be whether that's a topic that we want to continue on and talk about. Like, obviously there's been developments in that area with sandboxes in Arizona and Utah, and whether that's something of interest. I mean, I feel like those topics tend to be covered a lot in April, if anyone's a member of April and involved in that. And so there's always that sense of not wanting to do what's being done by other legal ethics organizations. And there's some crossover, but not, there are a lot of members that aren't members of April that might find those discussions interesting, and potentially getting a member of, that current group to talk about what they're looking at and considering, like we did with ADLs. That could be of interest.
Yeah, that's the Closing the Justice Gap Working Group. They are working tirelessly right now on creating or recommending how to implement a regulatory sandbox. Their final report's not till September of 2022. So I'm not sure it'd quite be ripe for discussion, but maybe a year, and maybe April 2023, there might be more meat on the bones to dive into that. Unless you wanted to talk, and Dina's right, I mean, other groups focus on these issues, unless, and now I'm talking out loud, it probably wouldn't be best for the California Committee on Professional Responsibility to dig into it. And that is, these sandbox and innovative efforts that are occurring nationally. So maybe waiting till 2023 to focus on the sandbox initiative in California might be best.
That makes sense.
There's another area that I've kind of been thinking of, and it has to do with entry to the practice of law. And so it might be more adjacent, but I thought I'd throw it out there. There have been what you might call sea changes in our bar examination. And there have definitely been people who have problems with it. Some people who are very much in favor of changing the bar exam and changing what it looks like. And then some people are very opposed to it. But because that has to do with entry to the practice of law, I thought it might be something that we might consider discussing at a symposium.
You thinking, Hunter, changes to the bar exam, how it impacts those who potentially become lawyers, i.e. is it suggesting maybe the bar exam is easier, so lowering the bar for who's going to be a lawyer? What were you thinking?
Well, I don't have this really set up as a specific question or a specific issue. But when you first, or at least when a number of classes, when you first teach about legal ethics, you kind of introduce it with the entry into the profession. And the bar is kind of at the threshold of that. I don't know that it's necessarily in our wheelhouse. And there's definitely elements of the state bar that are on top of that, the committee of bar examiners. But that being said, I can tell you that and full disclosure, I teach at the Kern County College of Law, which is through the Monterey College of Law, and the dean of that school has very prolific about his views on the bar. And I'm not suggesting one point of view or another, but I've heard from local attorneys, when the bar comes around, like, oh, these new people, they're not going to be competent. They're not going to know what they're doing because these lowered scores. But I don't know that it's necessarily in our wheelhouse, but I did want to put it out there. If that sounds like something we might be interested in discussing.
Makes sense. Thanks, Hunter. Any other brainstorming ideas?
One other topic that was listed here before that wasn't considered, and we've talked about it as a potential opinion, although we haven't really narrowed the scope, it just sort of relates to in-house counsel and legal ethics issues with in-house counsel. There's a lot of issues there. We did that one outline where we flagged a bunch of legal ethics issues that relate to that. I don't think there's a lot of opinions out there that can relate to, like, there could be a lot of topics that could be covered related to, like, lateral moves from in-house and, just different types of ways in which in-house is different, but yet has to comply with some of these rules and, or all the rules to the extent they apply. But anyway, I just thought, and I think there are some people that maybe regularly advise in-house counsel lawyers, and conflicts are slightly different. So I just thought that there might be some meat on that. And I don't think there's a lot of opinions out there about some of these issues related to in-house counsel. So that's throwing that out.
That's, yeah. I was just thinking about our audience. I think Andrew made the point, we have a certain audience that tends to come to our symposium. And if we did an in-house counsel presentation, I could see a number of in-house lawyers who might not otherwise come to our symposium and be interested in doing that and hearing about that.
Sorry.
Go ahead.
I would second that. Conflicts issues are huge. and there's a lack of clarity out there on how to deal with conflicts and disqualification. How does that even work for in-house counsel, and mergers and acquisitions, and how they deal with, what happens to their company that employs them once it's merged with another company, deals and things like that. So there's a lot of issues, I think, that can be explored there.
Justin, can I suggest a topic?
Of course.
A recognition and elimination of bias topic. A few years back, I believe, we did a course that got partial credit for recognition and elimination of bias, and it seemed like our attendees were really grateful to have an ethics / recognition and elimination of bias type course. And I don't have a specific idea on what it would be, but maybe somebody can come up with something that would qualify as both, and would be, I think our attendees would really appreciate the opportunity to get that kind of credit from our symposium as well.
Yeah, that's actually the one I circled on page 2. There was reference to implicit bias training, and I thought of elimination of bias credit, and then how can we tie things like even legal ethics and diversity and inclusion, which are obviously very important subjects in the legal profession. I have a great resource at my firm that I can talk to about these things. He goes around the country and talks about diversity and inclusion issues as they relate to law firms and lawyers, and so there are many people who are passionate about these issues. So, and it's obviously very ripe for discussion. So that's a great topic to consider. Well, we've got a good start here. Any other brainstorming ideas? And while people are thinking, let me ask Andrew, historically, and Mimi as well, historically, timing wise, does it make sense to maybe offline have some contact with those who might be candidates to be moderators, get a sense of whether they're interested, sometime in the next couple of weeks, and then get some more specific feedback from them about the potential topics. How does that typically work in terms of timing?
I think typically at our January meeting, we nailed down, right now we've got a bunch of lists of topics. I think typically we give you guys another meeting to come up with more ideas. And then at the next meeting, and correct me if I'm wrong, Andrea, but usually that's at that point we vote on, or we take like a straw poll on what people think is the most popular ones within our group. And then after we've nailed down the topics and we have volunteers say, hey, I'd like to moderate this one, or I'd like to at least be on the panel for this one. Just to give you an idea of what the schedule looks like, and this is not for this year, this is a past year schedule, but in January, we nailed down the topics and identify potential speakers / moderators. You guys have the rest of January and usually February-ish to find speakers. And then we send out the save the date February 3rd, or the first week of February, I guess. So we have a little bit of time to maybe brainstorm or refine the ideas a little bit more and come back at the next meeting and have a full discussion, and at that time select the panels before selecting the moderators.
That's very helpful. Thank you for clarifying the order. That's great. Any other ideas here to put on our list? This is not, we're not certainly precluded from adding, and if anyone has ideas between now and January, again, please email us and Mimi and Andrew, and let's have those added for discussion in January. It's kind of an organic process here, and then we'll vote on the topics at our January meeting.
That's right. I'll just say as a general plan, staff will recirculate the list of items that you just looked at the top for the quote unquote agenda item for the January meeting. But between now and January, you are free to brainstorm. And if you come up with ideas, you can email me and myself and Justin, and we will add those to the list with the goal being to identify and select 4 topics at the next meeting so that we can begin in earnest meeting the project plan / deadline schedule that Mimi just shared.
Also, if any of you who suggested these topics have a way to maybe narrow it a little bit, because right now, for example, we wrote billion liens or cryptocurrency, maybe trying to narrow the focus. It doesn't have to be a full-blown summary of what the panel could be, but just maybe a sentence or 2 on, or just even a list of ideas of what could be covered. That'd be really helpful.
Right.
Okay, so we move to our next topic. So we had public comment this morning, and I'm sure everyone is still digesting that. It was really nice to have 11 individuals appear or attend to provide us with their thoughts on the issue of the campaign contribution and prosecutorial conflict matter. And I know that folks are probably still digesting those comments. And certainly I want to give everyone the opportunity to do that. But I at least wanted to, since we had those comments today, give the committee an opportunity to discuss, if they would like, any of those comments and what our sort of next steps might be in terms of considering those comments and any further recommendations that COPRAC might provide to the State Bar. But before anyone, I want to open it for discussion if anyone wants to talk about it today, of course. But in terms of process, maybe, excuse me, maybe before we open this for discussion, Andrew, it might be helpful to, if you could kind of give us your view of, what is presently being asked of COPRAC in terms of considering this issue further, and then we can go from there.
Absolutely, and this might be most helpful to our new members who might be curious what this is all about. I hope the agenda item was sufficiently descriptive, but it certainly may have failed in that regard. Our returning members probably remember this topic, and it originated last summer when 4 district attorneys submitted a letter to the State Bar requesting that a rule of professional conduct or an ethics opinion which would prohibit an elected prosecutor or a candidate seeking election from soliciting or receiving political or financial support from law enforcement unions. And a representative of that group was here this morning, and she provided public comment in support of that proposal. And so following receipt of that letter, the chair of the Board of Trustees and the vice chair asked COPRAC to conduct, a detailed analysis of the issue, and COPRAC did. We spent quite a long bit of time last year, held a specially set public hearing, and discussed this item at several meetings. And the work of those efforts was culminated in a December 2020 memorandum, which was presented to the Board of Trustees in January of this year. And it provided the board with 4 options. The board could adopt a rule, pursue an ethics opinion, pursue a comment, monitor existing legislation, because at the time that the presentation was made to the board, the proponents had a legislative author to provide a legislative amendment to achieve largely the same goal, or to create guidelines for prosecutors, which would be non-binding, something that the ABA has. And the board directed staff, so not the committee, but staff, to monitor legislation and reach out to the legislature to offer technical assistance in 2021 with respect to that bill's efforts, which staff did. And then where COPRAC comes in is it's asked that following the consideration of the legislature's activity of this issue in 2021, COPRAC is assigned to determine whether revisions to the rules of professional conduct or the development of an ethics opinion would be appropriate. And although a bill was introduced, no bill was enacted last year, and we don't know why. I tried to glean as much as I could from the legislative analyses, and I included those potential options. I don't know that any of them are are viable or actual. Again, we're just speculating. I don't know. We don't know why it wasn't adopted. But the memo, the COPRAC memo, again, did a detailed study identifying some concerns with the rule approach. Some of those concerns would be present with an ethics opinion approach. So we're kind of back to where we were a year ago. There's no further legal change or authority for us to hang our hat on with respect to an ethics opinion. However, we could do an ethics opinion under a 1.7b analysis, should we choose to. We could look at a rule, but the rule is still fraught with the same issues of the constitutionality concerns that COPRAC identified in their memo. Or we could do a comment to the rule, which is solidified because it would reference existing law. We wouldn't be making the law, but it might be less than satisfying to proponents. Or we could continue to monitor criminal justice reform efforts, as we know every year, rightfully so. There's additional criminal justice reform efforts. And as those develop, either in common law or through statute, we might have something more to which we could develop a rule amendment or an ethics opinion. So that's just my view. Those are the options. We're not stuck to those, and that's where we are. So again, the assignment for COPRAC is to consider legislative activity from 2021, which there was a bill introduced but was not enacted. Following that activity, the committee is being asked whether a rule or an ethics opinion should be developed with respect to this issue. And so I've tried to identify the 4 options in the memo, which would be go with a rule, propose a comment to a rule, pursue an ethics opinion, or monitor further developments.
Just to clarify, Andrew, what you just described in terms of what we've been charged with, that is a subsequent task that the State Bar has, instructed us to perform, meaning we initially looked at these issues and prepared a detailed memorandum based on the request of the State Bar. And now subsequently, the State Bar has given us this additional or new task related to the first one, which is to consider whether or not a rule or ethics opinion would be appropriate at this time. Is that right?
Yes, I think I understand what you're saying, but yes. So we did a study, we presented it to the board, gave options to the board. At that time, the board said, let's monitor legislation, but we don't know what's going to come out of those efforts. So once the conclusion of the legislative session has occurred, COPRAC is assigned to, in light of this new information, what occurred in the legislative session, determine whether revisions to the rules or development of an ethics opinion would be appropriate.
Okay. Has the or do you have any intel or information from the bar as to procedurally, how it is they are looking up to the committee to convey, if we reach a view, how it is the State Bar would like us to convey that view to them. Is it a letter saying, hey, we think this option is makes sense, or that option makes sense, or something else?
So it's my view is that it depends what the committee ultimately concludes. So I think the committee should focus on their good thoughts and whatever direction they would recommend. And then depending on it, if it's a rule, we're going to work up the rule and it's got to go through the board to go out to public comment, or a comment to a rule. Similarly, we'd have to work up the language, send it to the board, and it would go out for public comment. If it's an ethics opinion, that can be developed here, and staff could, report to the board that development. They would see the ethics opinion if and when it comes back to the board for a request for publication. And if it's a request to if it's a decision to monitor, staff could work with executive staff at the State Bar to determine, how best to convey that.
Okay, let me just follow up on that, because I just want to make sure everyone on the committee is kind of understanding the process that we might go through depending on the options. So we're all thinking about, conceptually how this would work. So if we, take the writing an ethics opinion, we do that all the time. We work up our issue outline, we flesh out the issue outline, we draft an opinion, and we could let the State Bar know that's the option, let's say. But if it were, say, a recommendation to comment, to add a comment to the rule, or to even have a new rule, that is probably something that would, in contrast to just drafting an ethics opinion, probably necessitate a letter to the bar explaining our view that, there should be a rule, or there should be a comment to the rule. Here's why we think it, and we wouldn't just then go and draft a rule. Presumably the State Bar would weigh in before we started a rule drafting or comment to a rule drafting process. Is that a fair distinction between, an option like drafting an opinion and the process for if we were to do a rule or comment to a rule?
You raise a good point. I don't know I think my advice right now is I wouldn't worry so much on the process. I would focus on, what the committee believes is the best course of action. And then depending on what the committee determines, staff can work to develop, give you guidance on how best to convey that. I wouldn't want the process to affect, whatever the committee's good and best thoughtful advice is.
Oh, for sure. The process, I agree. The process,
and we'll help you. I mean, that's staff's job.
Just
advise you.
Helpful to know what the process will be, so that we can kind of prepare in terms of our time and efforts, and make sure that we can devote the resources necessary to the work. So that's kind of that's why I'm asking those questions.
No, you're right. I mean, that's a good question. I mean, let's get a sense of the committee first, and then you raise good questions as to whether or not we should take the time to work up the rule. If no one, anyway, we should. I wouldn't focus too much on the process right now. Let's have a discussion. I would encourage you guys to have a discussion to get a sense if there is any consensus amongst the group. I mean, that will help inform a lot of how to go forward.
Right. So, Andrew's outlined some of the options that we could potentially recommend. And again, I appreciate that we just had the public comment this morning. Many of the comments were very helpful. It's always good to hear from the public and views on both sides to help us, make an informed and thoughtful, to inform our how we process this these arguments on both sides. and try to come up with, you know, an appropriate recommendation. And so that's great that we have that this morning. And so understanding that it was just this morning and you all are probably still thinking about what you heard, and you know, I would open it up to any thoughts that committee members have, so we could, you know, start getting, you know, some discussion on this rolling in terms of the, either, you know, whether or not any of these options are more viable or appropriate than others. Does anyone want to share their reaction to?
Justin?
Go ahead,
can I
Joe.
offer just a quick take on this? To start us off, first of all, it's a problem. Taking contributions from organizations who represent police officers that you may be required to prosecute or to deal with, and particularly in the area of the justice system, is a problem. I don't think the solution is barring individual police officers from contributing to their campaigns. I don't think it's the solution to bar organizations from contributing to their campaigns. Those, you've got your free speech issues and political activity issues, and I was pretty impressed with some of the reasons they gave in the public comments. As far as what we might do about it, well, I think the solution is the legislature, and the legislation should be that any prosecutor who has come to office by soliciting contributions from law enforcement should be required to recuse themselves in any case which impacts a decision about conduct of law enforcement within their jurisdiction. And if the legislature decides not to pass it, we might consider, and I haven't thought it through or done any research, whether we would have an opinion that might say it would be unethical for a prosecutor who has solicited such contributions not to recuse themselves. And that's where I come out on it, and I just threw it out.
Well, I appreciate you sharing your thoughts on this, Joel. It's you know, there are obviously the proponents and opponents of the you know, proposal, you know, express, I think, you know, their views, and both sides feel very passionate about their views, and you know, we are tasked with trying to come up with what is the most appropriate option for you know, for the state bar, and you know, these are challenging issues to deal with, and we all, I think, are, you know, sensitive to the issues, and it's you know, appreciate your candor, quite frankly, to hear your perspective. Does anyone else have thoughts that they want to share about our potential options for this?
I just want to ask a question, and I'm not familiar with this as a new member. I'm not familiar with this issue as much as many of you may be, but the recusal, what Joel is saying about, you know, they should recuse if they solicited or received any contributions. So would that's the district attorney who was elected, would that then apply to the whole district attorney office? They would have to be recused from that particular case of prosecuting police misconduct, and then what, the attorney general has to step in and take over the case? I mean, how does that work?
I haven't thought it through. I'm not that familiar with the criminal law, but I do note in the prosecution in Minnesota arising out of you know, the Floyd case, that whole office did recuse themselves, and they brought in the state attorney general to handle the prosecution. So there's got to be some process that can be worked here. You know, I'm a special deputy trial counsel for the Office of Trial Counsel when they have a conflict, and we have a system or an alternative here. There can be things worked out I just haven't thought them through.
Yeah, I mean, me too. I haven't thought it through either, but my thought was that if it's a, well, it seems very political, because the police officers will be contributing to the conservative DAs, to be elected. So it would work out that most of the time a DA who's conservative would be the ones that would, always have to recuse themselves. So it would turn into sort of a political issue if there is an automatic recusal requirement. But, I'm just kind of thinking how the political issues interplay with that type of requirement.
I just think that what's going on right now is approaching it the wrong way. I do not think COPRAC should be telling individual attorneys who happen to be working in the justice system that they can or cannot contribute to political candidates.
Yeah,
that's wrong. So
right.
if COPRAC's going to be involved, I think it should be from the other end. But
yeah, I would agree with that.
One of the questions I have is, and I'm sure since I'm a newbie here as well, I mean, in the course of this analysis, we look to the canons on judicial performance to see how the judges are treated in terms of campaign contribution. Because, correct me if I'm wrong, I think the letter from the 4 DAs mentioned the fact that they believe, I mean, they're almost quasi-judicial in their job function in terms of who they decide to prosecute and whatnot. And so it seems to me how the Commission on Judicial Performance treats or deals with campaign contributions to a judge, which I just kind of scrolled through Canon 5 right now, talking, and it's really in the context of attorneys giving campaign contributions to a judge. There's no prohibition against that. And
in California, if you run for a judge, I think if you take a contribution of $1,000 or more, you've got to post that in your courtroom. And if you take a contribution for $10,000 or more, you have to recuse yourself.
Yeah, I
think that's the rule.
Yeah, there were some, like I said, I just briefly looked at, there's some recusal under 170.1 dealing with that issue depending on the amounts that was disclosed, but I kind of agree with Cassidy and Joel. I'm not sure this is something we should be doing a rule about. Maybe we comment on 1.7 in this context.
So if I can speak briefly, it's troubling to me because I do think this is a very real issue. And I similarly think this is absolutely the wrong way to attack a really profound issue. And I think what we were just talking about with the triggers for a judicial officer having to disclose or recuse herself, those are not directed at a particular person or viewpoint that has donated. And I think that's really problematic here. We're only talking about this for police officers. Right. A DA can be biased or allegedly biased in a million directions by powerful campaign contributions, but we're really only focusing on like a viewpoint specific electoral free speech issue, which I think is like triply problematic. And it concerns me a lot. I think there's legislative approaches that can avoid all of these issues, where if for certain types of cases, they are handled by, state prosecutors or taken away from a particular jurisdiction or something like that, having nothing to do with the contributions and not touching those issues that I think are more optimal to address the challenge. And I think it's really problematic if we get involved. And I'm not trying to just kick the can because I think it's a really important issue, but I don't see how we make it better. That's my view. I would favor option 4 from the memo.
Meaning essentially monitor the legislative activity.
Yes. I don't know why that reform measure didn't pass. I admit I just didn't follow it carefully enough. I thought it was going to, and let's monitor it.
And I guess one way to look at it too, you can, if you wanted to go down to a simple comment or a rule of some sort, I mean, it seems like you should we should model the Canton 500, the Commission on Judicial Performance, where you're not limited just to police officers, the law enforcement union, anyone, any
Right.
person or an organization who, you know, provides X dollars, above X dollars to the candidate for the district attorney, either this first got to accuse themselves, they got to disclose it, something along those lines. So it's
If we
neutral.
believe a campaign donation
Yeah.
creates a disqualifying conflict of interest, that concept, I don't understand why it would be limited to this one very critical issue, but exclude all the rest, all the pollution or, you know, industry, whatever else that you can think of.
Just in case I'm not exhibiting a poker face, and for all the new members, I want to I've been recused from this topic, so
Oh,
I am keeping
You guys do a lot of that.
silent and trying to avoid any facial expressions.
That's the same for me.
Go ahead.
I did want to ask Hunter a question. I don't think this is an issue. Some of the comments today did mention that there is a process for when, and I don't know if they're just referencing 1424 under the penal code, but for when a district attorney is to be recused. And we did address the issue in the memo as to whether or not imputation from the elected district attorney flows to the entire office. I mean, a lot of these are procedural issues that are tough to address in the rule of professional conduct. I think Cassidy and Bill are identifying that. But Hunter, I wonder if not giving your views as to, you know, what's good or what's bad, if you could just, from an educational standpoint, I don't mean to put you on the spot, but how recusal generally works in a district attorney's office, and if you know anything about recusing an entire DA's office.
Well, typically well, for one, it's very rare. Two, it's the issue that's brought up here is essentially the worry that someone will not be prosecuted, right? That's the worry. But generally, you don't recuse an office for not prosecuting your client. Usually, if there's going to be a motion for recusal, it's not going to be for failure to prosecute. That being said, there have actually been changes in the investigation of officer-involved shootings or officer-involved use of force that lead to a person's death, where the attorney general is involved in the investigation. You can actually just kind of Google News this, you know, officer-involved shooting, attorney general. So that could probably inform part of the reason why legislation went the way it did, because after June of 2021, certain rules were in place where the attorney general involved themselves. And I know at least locally, we've had attorney general or state level law enforcement coming in to investigate that kind of thing. So in terms of the process of recusal, typically there's a charging decision. I couldn't say that 1424, I think you might even have a ripeness or mootness issue if somebody tried to recuse from reviewing. And I'm pretty certain, although this isn't something I've dealt with before, I'm pretty sure if the attorney general wants to come in and investigate and then prosecute on their own, they can. So I can't give you more on the nuts and bolts of it, except for that I've never seen somebody try to recuse us for failing to prosecute their client.
Is AB 1506 what you're identifying with respect to attorney generals getting involved in officer involved shootings, or is it, which is now government code 12, whatever it is, 323, it's in the memo, or is it another authority that you're referencing?
That does sound correct. I can tell you from my current work that I'm aware of the effects, but I was not following the legislation when it was passed.
No problem. No problem. Okay, thanks.
So can I ask another clarifying question? So currently, though, if there is a quote unquote conflict of interest based on a contribution, how procedurally would you couldn't file a motion to recuse under, or who would file the motion to recuse under 1424? Because that's the penal code. It's pretty specific. It has to be, the defendant won't get a fair trial, right? And so that would not be an issue. And I know that this has come up in the context of in LA County, where Gascon was hiring public defenders and from the, as DAs, and they filed a motion, the DA, former DAs were filing motions to recuse certain DAs who are former public defenders based on this quote unquote conflict of interest of switching sides, which I don't think it prevailed, but it really didn't fit into the 424 paradigm. So
the advent of Mr. Gascon's election and new policies is,
right,
in my view, is probably going to be creating some very interesting ethical case law in the next few years because of this, because of specifically, and that includes, of course, like potentially, at least there is a lawsuit alleging the violation of employment law for some of the reasons. So I think that's a barrel of worms.
well, it's before the Supreme Court now, right? I mean, they've got Neil Katyal as their lawyer, and I mean, yeah, no, I know, I'm aware of all that. So I'm curious how this all kind of fits into it, and it's all politically charged, frankly. So, but I kind of got off track there. I was just asking about, like, how do you deal with these conflicts in a motion to recuse situation? There really is no statutory mechanism at this point.
Yeah, generally statutory mechanisms are there to protect the accused.
Right.
And this is kind of the first time we're seeing kind of grassroots, if you want to call it that, although I don't know that would be an apropos term. We're seeing a movement towards a kind of specific desire to prosecute. And so, and you'll see this from time to time, like Marzy's law, things like that, where some law will come up that says, we kind of demand prosecution, or we demand certain terms of punishment. But yeah, you are pointing out an interesting issue, which is how would that mechanism even function?
Right.
And just a lot of what we're talking about was identified and addressed in the COPRAC memo. It is 20 pages, but again, I just want to really congratulate and applaud the committee on their work, and just especially for the new members. I know this can be overwhelming. It wasn't overwhelming for us in hindsight, but at the time it was a lot of work. I'm being facetious. It was a lot of work, and we worked really hard, and a lot of these issues are addressed in that memo. So if you want a good orientation, I definitely encourage you to read it. It really does crystallize the issues which are still present today for this committee, with the request to make a recommendation as to whether to pursue something because no legislation was enacted. So we're kind of back to square one, but we do have the benefit of that analysis that we went through.
Yeah, it seems to me, and let me know if anyone has a different view, that it would be helpful for the committee members to digest the conversation we're having today, digest the public comment that we received today, and look back at Andrew's December 3rd memo, and then COPRAC's earlier memo, the 20-pager that he's referring to. And with all of those in mind, we can have a substantive conversation in January about these options and what we want to do about them, and have that and perhaps reach that conclusion in January. I don't think that we're in a position to do that today, although it's been extremely helpful to get people's thoughts on these issues today. And so I would be inclined to give everyone a chance to think about these matters a little bit, even more fulsomely, and then reach a consensus in January. What do you think?
I agree.
Yeah, I think that makes a lot of sense.
Okay, so then I think one of, a task for all of us in terms of homework is to, put together our little mental care package of the 20-page memo, Andrew's December 3rd memo, and all the attachments, the public comment that we received today, the comments that we've had and discussed, and then we can decide on what we think is an appropriate course of action in our January meeting. And then have a further discussion then.
Can we prevail upon staff just to repackage all that stuff and send it out to us for some of us who've been too quick to the trash can?
Yeah, no problem.
Thanks.
Okay. Any other thoughts or comments with respect to the campaign contribution subject?
When did the public comment for that end? Has it happened yet?
So there was no formal public comment period. Every meeting last year that the item was on the agenda for discussion, I think every meeting except perhaps one, we received public comment. And then we held a special meeting on August 11th, which I think it wasn't a Friday, for the sole purpose of receiving public comment and testimony. And then just as any other meeting, we heard public comment today. So it's not like an ethics opinion that nothing's gone out for quote unquote public comment, but we've been receiving public comment throughout the time during which this item's been on the agenda. I hope that answers your question.
Okay.
And Hunter, I just want to say, I think it's a resource to the committee for you to be able to share, your views as a district to educate us, as to what a district attorney does. So it's my personal view that, sharing factual information, procedural information, I think it would benefit the final work product of the committee.
And to the extent that anybody has any specific, factual questions about that and wants them perhaps answered by the next committee meeting, I'd be happy to do some research, since that is the area and it's at my fingertips. So I'm happy to do that.
Thanks. So we only have 12 minutes. I don't think it would be fruitful to try and start and stop the client file retention discussion. And we've had a very wholesome day as is. So, I'm inclined not to start a new topic in the 11 minutes we have. But if there's any other, anything else anyone wants to talk about, happy to do so in the time we have. Otherwise, we'll let Andrew go a little early for his last COPRAC meeting as a special thank you.
I mean, woohoo, you get a whole 11 minutes off early, Andrew. I mean,
sounds
now
like
that
a
we're going
plan.
to continue to talk, it'll be more like 10 minutes, but
It's
I
all
just want to
good.
say, as a newcomer, I feel deprived and robbed and really like I got the short end of the stick for not having the opportunity to work with you for longer than a couple of months, Andrew. So hopefully our paths will cross in some other context, but I wish you the best and wish I had gotten a chance to get to know you and work with you.
I appreciate that, Elizabeth. I hope our paths will cross too, but most people show up at your wedding and your funeral, and they only say nice things at your funeral. So, don't be jaded by what was shared about me today. It might not all be true.
Well, I share Elizabeth's comments as well, Andrew. Wish you best of luck.
I
Really
agree.
appreciate that. Thank
It's been
you all.
short, but it's been a pleasure.
And for those of you guys that are new to the committee, also, just so you know, I mean, Mimi's been on the committee forever
Yes.
too, and she's amazing. And so while we're losing Andrew, which is heartbreaking in some ways, Mimi's the backbone too. She's there, like she'll guide us. So it's not like we're losing both of them, which would be much harder. So
Yes, that's extremely important. I talk way more than Mimi, but Mimi does way more of the work behind the scenes. So you guys are going to be in great hands. Never fear.
We still have 18 more days to harangue you, so this is not goodbye just yet.
That's true. I'm going to get out these these materials to Joel and the committee as you've requested, and we'll continue working on these important topics.
Well, thank you, Mimi and Andrew, for everything. I hope for those of you that I don't speak with before the holidays, whichever holidays you celebrate, that you have a wonderful holiday season, and I hope you all get restful moments and time with your families, and looking forward to our January meeting, and have a wonderful rest of your month, and Happy New Year. Can't say enough thank yous to Andrew for everything, and we all wish you the best in your future endeavors.
Thanks, you guys too. Really appreciate it.
I'm just going to mention one more thing. The two opinions that weren't talked about today, the client release and file and release and retention and contingency fee agreements. I know we didn't get to it, and it'll be carried over to the next meeting. But if you want to circulate additional materials for the next meeting, that's great. If you're not planning on circulating revised materials, please let me know so I'm not sitting there waiting for materials. So that'd be really helpful.
Makes sense.
thanks,
Okay.
Mimi.
All right. Bye, everyone.
Okay, bye-bye.
Bye.